Crooked Fanny playing dirty tricks in the courtroom. She always picks, bending the rules. She'd know win, but I won't let her get under my skin. Down in Georgia, where the blues run deep, crooked justice, a secret they keep. But I see through her lies, I see the truth. Gonna make her pay for what she do. Fanny's got a reputation to uphold, but her tactics are shady. Story untold, she thinks she's clever, but I'm on to her game. I'll expose her ways and put her to shame.
Hey yo folks, and welcome. As you see, this is a new setting. Yes, I'm at Dave's place, the end station of my road trip across the United States. Now, I will be here for a few days. There will be a lot of more things to do. So don't you worry, folks. On my road trip channel, there will be stuff. There will be stuff. Tomorrow, I am visiting the Henry Ford First Factory. But, folks, we are here for the Young Thug trial. Now, yesterday was again a bit of a travel day for me, so I didn't catch all of it, except the usuals that, well, ill-prepared prosecution. And I do, again, believe that it's intentional. It's bad faith. But proving it is another thing. Yeah, I'm trying to get used to Dave's setup here, which means camera there and stuff there. And apparently a microphone. That's handy. Yes, I am in the treehouse, and it's much, much tinier than I expected. Hopefully, I will survive. No, I'm not sitting on. Jack, Matt, behave. I'm not sitting on the toilet. But yeah, we are here for this. And today I have a bit more time since I don't have to rely on my laptop with serious battery issues. So we will go through today as a recap, which means we can play it a bit faster, we skip all the breaks, and fast forward through dead air. So yeah, today was an evidentiary day, and again, talking about what should come in, what shouldn't come in, these new insect, the new stuff the prosecution wants in, because they know what a horrible case they have. So they do anything to put anything else in. And yeah, 4x4. I can probably, well, not reach across. Maybe it's 7 feet by 7 feet, something like that. No, he's not going to make me sleep in the treehouse. No. And if he does, I am going to pee out the window. It's 8 by 8. Okay. Ah. It's not tiny, Mom. Dave. Yes, it's jail cell sized. It's jail cell sized. But okay, let's move on with day 115. And they will really enjoy me changing some of his. Yeah. Oh.
I see on the Rodelius Ryan exhibit. So we're working on those.
Okay.
We won't. We'd rather continue working on those than even attempt to start addressing that part
Okay.
today.
That's fine.
Yes, Your Honor, we're going to wait to file our motion in limine because we are working with the state. And we want to make sure we're not wasting the court's time.
Okay, I appreciate that. Sure.
And I meant to bring this up
Cheers.
earlier today. I'm sorry. I have a client that's scheduled for a bond hearing at 2. I have another attorney coming in with the court's permission to sit with Mr. Stillwell briefly for about 15 minutes while I conduct the bond hearing, if that's okay with Your Honor. It's on Zoom.
Is it okay with Mr. Stillwell?
Mr. Stillwell, he usually works with me. Did he say yes?
So it's fine with you if he takes a brief break? Okay, well, obviously hurry back because you seem to be the main person making a lot of the evidentiary arguments. So
Yes, Your
we'll
Honor.
miss you while you're.
Hello. No, I did not see Steele argue State v. Ryle appeal at Supreme Court. I'm going to get to it, but I do believe I have too much on my plate at the moment, so I have to wait until I get back to Sweden for that one. But I heard it was great. All right, let's get back to the trial.
On.
All right, thank you.
All right. Anything else from anybody? I know, Mr. Matthews, you had let me know after we went off the record yesterday in the presence of the state as well that you wanted to circle back on one of the items of evidence that we had reviewed yesterday. So you can go ahead and do that.
Would you like to do that now?
Sure. That's discreet. We can go ahead and get that taken care of.
Yeah, hit the thumbs up, folks. It's free and it helps the channel.
Judge, we're before this court representing Mr. Marquavius Huey on this matter. There's an intrinsic act that was listed in the state's notice to us back in November of last year concerning item 43, which is an intrinsic act that the state is alleging should be coming into this trial. Your Honor, that particular intrinsic act stems from a November 30th, 2021 alleged incident. It's a police chase, Your Honor. And that police chase, the state are presenting to the court that this intrinsic act is somehow connected to this case and should come into evidence. That's the issue before the court. The rule that I'm asking this court to apply in this particular case obviously deals with intrinsic acts and what are the requirements for them to come in. As the court is aware, and I've cited for the court Murphy versus the state, 354 Georgia App 560. It's a 2020 case, and the case stands for the proposition that in order for intrinsic evidence to come in, evidence is admissible as intrinsic evidence when it is an uncharged offense arising from the same transaction or series of transactions as the charged offense. So the charged offense in our case, Your Honor, is stemming from an October 1, 2020 alleged armed robbery of a deceased individual, Gary Holloman, from October 1, 2020. So it is not meeting the threshold of being an uncharged offense that is arising from the same transaction or series of transactions. Number two, for consideration for this court is whether or not this particular alleged evidence is necessary to complete the story of the crime. Again, we're talking about a November 30th, 2021 police chase that is not necessary to complete any story of any alleged armed robbery of Gary Holloman on October 1st, 2020. It's not necessary to have the state provide more information in order for them to complete the context of their story. Number three, for the court's consideration as adopted from the 11th Circuit, is whether or not this particular alleged conduct as an intrinsic act is inextricably intertwined with the evidence regarding the charged offense of the armed robbery from October 1, 2020. According to the court in Murphy, evidence of other acts is inextricably intertwined with the evidence regarding the charged offense if it forms an integral and natural part of the witness's accounts of the circumstances surrounding the offenses for which the defendant was indicted. So it's not inextricably intertwined from the standpoint of the November 30th, 2021 alleged this police chase where they're alleging that Mr. Huey was involved in this police chase. There's nothing about the October 1, 2020 case that involves a particular vehicle that is supposed to be part of this police chase. So there's no connection there. With respect to the police chase itself, the vehicle was not apprehended. That's number one. The chase was ultimately called off. The identity of the driver on that day was never established through any apprehension. The vehicle eluded law enforcement. There were no admissions through any subsequent arrest that was made on Mr. Huey of any admission to even being a part of this police chase, being a driver in this car. When you look at the video, there's no photos of Mr. Huey operating this particular vehicle. There's no ownership information that would show that he actually was operating this particular vehicle on that day. And the vehicle is not the subject of having been used in this particular alleged armed robbery on October 1, 2020. So the vehicle is not a nexus to any of the charges. And so the vehicle would not make it necessary to complete the story of the alleged crime in this particular indictment. So what we have here, Your Honor, is a separate alleged crime here of a police chase that the vehicle was I think it was a burgundy Nissan vehicle. It was fully dark tinted up. So no one could see inside the vehicle from the windows to the vehicle because it was fully tinted. So when you look at what we have here, we're having a separate incident that is over a year after the October 1, 2020 alleged armed robbery. And just to give the court some context on October 1, 2020 alleged armed robbery. So Mr. Huey was arrested on those charges for the October 1, 2020 incident. When he was arrested, he sat in the Fulton County Jail for a period of time, and we had a preliminary hearing on the case, probably sometime in November or so of 2020, give or take. And that particular armed robbery offense, we were able to get the armed robbery case dismissed at the probable cause hearing for lack of evidence. And then the state, they made a decision to indict the case after there was a dismissal at the preliminary hearing stage. So subsequent to that, a grand jury indicted Mr. Huey on these charges from the October 1, 2020 incident. And when they indicted Mr. Huey, they added charges, and therefore they put forth a grand jury bench warrant. There's no indication that they're able to establish that on November 30th, 2021, when this police chase was involved, that Mr. Huey was somehow running from the police because he knew that there was a grand jury bench warrant or anything of that nature. In fact, Mr. Huey reported to court before Judge Donaway on the indicted case and was taken into custody in court.
When
So
was that?
that would have been in 2000. It was in December of 2021. Okay, so he shows up in the court and he has been in custody ever since. So as it relates to this intrinsic act, it just doesn't meet the criteria. Then the last step, Your Honor, I'd like to direct the court to Hines versus State. That's going to be 353 Georgia App 710. It's a 2020 case. So after the court does its analysis in terms of whether or not it is an intrinsic act that needs to be part of this case, the court then has to go to the next step of whether or not it survives a 403 analysis. In the Murphy court, the court stated that Murphy has not shown that this alleged deficiency prejudiced him, and that is his lawyer not objecting to certain evidence that was intrinsic coming in. So the Murphy court said, hey, listen, you have to show that you were prejudiced
Well,
by this coming
that
in.
was an effective assistance claim. That's
Sure.
a different kind of procedural stance than what you're talking about.
Agree, but I agree. What I'm asking the court to look at is if this court says, hey, look, I think that it is intrinsic. I do
Mhm.
think that it somehow meets one of those thresholds.
Right.
Then the court will go to the next step of whether or not there should be a follow-through analysis
Sure.
to determine whether it comes in. So with that being said, in Hines versus the state that I previously cited,
Mhm.
there was an intrinsic act, and the intrinsic act was some information that came into to that trial concerning that particular defendant. And in that reference, it stated that this particular defendant, there was a word that was used that she maltreated or injured or harmed her children, and the court believed that that was prejudicial. In this instance, Your Honor, if this court allows this scant piece of evidence that has not been established that it was in fact Mr. Huey that did this conduct, we now have to look at, well, what is going to happen if this comes in? If you review this particular video, Your Honor, this police chase, you will hear in the on the radio inside the police car as they're driving on the radio, they're sending out this information. These are the things that are quoted. He has a history of running, and he has all these warrants. That's in the video. Put some stop stakes in front of him. That's number one. Number two, he's armed and dangerous, known to carry a gun. That's number two. Number three, do you know where he lives at? And then they talk about his address. So these are all prejudicial items that are going to come into.
Yeah, Adkins didn't always sit between Love and Hilton. Now he's more of a barrier between them because, as you might know, I was in the courthouse on the 14th. Nobody in that courthouse, including the prosecutors, likes Miss Love. Not one. The judge tolerates her, but that's about it. It is so apparent, obvious when you're in the courtroom that really nobody likes Miss Love. At one point, she went back to talk to a few of the security personnel, doing jokes about the courtroom is quite cold, and apparently a vent is blowing at her. And she made jokes about it, and you heard from the staff that, you know, the fake laughs, and yeah. Maybe Glanville liked her a little. Nobody in this courtroom. All right, let's get back to the hearing.
Evidence if this court allows this particular intrinsic conduct, and that would prejudice Mr. Huey immensely here, because these are things that are going to go to his character. It's going to go to propensity, and it's going to suggest that there's some type of consciousness of guilt.
Let me ask you this.
Sure.
Is it possible that if I
Love
determine
is single.
that this is
Or
intrinsic, that
just
video could
alone.
be played without the audio?
I imagine they could potentially play it without the audio. But there, again, there are a number of hurdles here that I would submit that do not meet the threshold of coming in based upon those three items that are required.
Right.
So it doesn't meet 1, 2, or 3. It's over a year after the October 1, 2020 alleged armed robbery of Gary Holloman. This police chase occurred on November 30th, 2021. The vehicle was not apprehended. The chase was ultimately called off. The identity of the driver on the day was never established, even by preponderance of the evidence, which would be, I think.
Yeah, folks. The claims from the cops is that his client was in the car. Never proven, never shown. It was called off. Nobody knows exactly who was in that car. So why is it here in this trial from the prosecution? Because as with everything else in this case, it's gossip. That's it. An entire, almost now 2-year proceeding, including the pre-trial hearings, gossip. And good plea deals. I mean, if you have a few of the defendants or former defendants you're risking life in prison, but if you sign this, you will get a couple of years and a decade of probation. That's it. I don't like plea deals. I really don't. I think it's too... How do I explain this in English? People who are risking life in prison, and here you only need to serve 2. Yeah, that would make many people lie and say, sure, I did it. It's like prison snitches. They have every incentive to lie.
The standard for these evidentiary issues to come in. It was called off. There are no admissions, no photos, heavily dark tinted windows. So that's my position, Your Honor. I don't believe that this one would pass the muster and the requirements to meet the Intrinsic Act's threshold. And then after that,
it doesn't
that it's prejudicial
pass the smell
and should be
test.
kept out on that as well. Because as the court knows, when we're talking about the 403 analysis, it talks about and tells us and teaches us that we should not be allowing under 403 prejudicial items to come into trial that are scant.
Okay, I understand the argument. Let's hear from the state. And I appreciate you bringing to my attention that the chase was over a year afterwards and the circumstances of that. And I know that in the state's filing from November of 2023, they have the date. So I'm not meaning to suggest that they were trying to pull anything over. We kind of ran through that real fast yesterday and, just kind of talked about a fleeing that was after the armed robbery that's an overt act. And I just kind of was thinking in my mind without looking at all of the words, oh, okay, this is at the same time. So thank you.
You're welcome, Judge.
Yeah. And now the prosecution comes with the lamest, out of every piece of garbage they presented, this is so lame. This is so lame. Remember, nobody has any idea who was actually in that car. Not one. They might suspect, but so what?
Good afternoon, Your Honor.
Hello.
The state believes that this should be admitted as Intrinsic Act. Just a few things for dates, Your Honor. So the preliminary hearing for the original armed robbery was actually in August of 2021. It was August 24th, 2021. At that point, the judge reserved her ruling and ruled either the next day or subsequently. And
the case was dismissed, folks. The case was dismissed against Mr. Huey. It was dismissed. Hey, Sue. Oh, hello. Oh, I bet you have a story or 20 to tell. Yeah. And for you who remember the Zachariah Anderson case with Munch, who was facing between 20 years to life for possession with the intent to sell and everything, 20 kilos of different drugs, 20 kilos, and a professional career criminal. They placed him in Zach's cell, and all of a sudden, Munch told the court and the jury about Zach talking in his sleep. Now, if anyone is facing 20 years to life, Zach has never once said anything but that he is innocent. He's never talked to any other jail friends, kept to himself, didn't break, no nothing. But all of a sudden, he has a dream confession. And Munch, 3 months after Sachs' sentencing, was a free man. From 20 years to life to a free man, just because he told the tale of a dream confession. Yeah, and people wonder why I don't like snitches, or especially prison snitches.
Dismissed the charges. Then in November of 2021 is when the state indicted the case. So November 8th, 2021, with additional charges, and the grand jury warrants were taken out on November 15th, 2021. This chase actually occurs on November 30th, 2021, so about 15 days after the grand jury warrants were issued in this case. And
It
Your Honor,
doesn't matter.
on November 30th, 2021.
It's a year
Investigator
after.
Flores was actually conducting surveillance on Mr. Huey. So the notion that the police or law enforcement did not know who Mr. Huey was, they did know who he was. They were conducting surveillance on him and watched him enter into the vehicle. So they knew who he was once he entered into the vehicle.
They
tried to initially blue light
claimed-
him and pull him over. But
Was he driving? I mean, did they
He
see
was
him get
driving.
into the driver's seat?
he was driving. He was the only person in the vehicle.
This is what they assert to her, to the judge now. I do not think that. Now, I haven't read all of that case. I just read snippets of it that has been presented by other channels. I don't think Miss Hilton is completely truthful here about the situation. They might have seen him enter a car, and later they saw a similar car who they then chased, and that got away. But there is some time missing between Mr. Huey entering a car and the chase started. And it was dismissed.
Uh-huh.
They attempted to blue light him and pull him over. At that point, he took off and he, amongst other traffic offenses, went to the wrong side of traffic.
Yeah. Yes. Munch, 3 months after the sentencing, he was a free man. And upon information and belief, he is in Florida. You're welcome, Florida. But I do have not a bulletin, what do you call it? But I'm keeping track. And the moment he screws up again, because he is a career criminal, but the moment he screws up and puts himself into jail again, you're going to know it because I know it, and I'm going to report about it. And I'm currently having the question out in here and there in Wisconsin. How many times did prosecutor, what's his face, use prison snitches? And how many crimes have these prison snitches committed since they testified for him? That will be interesting once I get that result. But we are here for this one, the Young Thug trial.
Traffic. They were then able to get the Phoenix air unit up to follow him. And the reason why the chase was called off, Your Honor, is because Mr. Huey
Thank you, Sue.
drove and restricted airspace. So the Phoenix unit could no longer watch the vehicle because he was near the airport. And so they could not go any further. So they had to pull back.
Oh, by the way,
to not
Kat,
keep eyes on him. So that is why the chase was.
Okay, well, let me ask you this. So,
sorry for pausing, but you know it's my channel. Kat Not Williams, welcome to becoming a moderator. Hey.
I mean, you have evidence that it was Huey who got into the vehicle and who was driving the vehicle and that he fled when he was blue lighted. Do you have any evidence that he knew that the reason well, two questions. Was the reason they blue lighted him because they were about to arrest him on the grand jury warrant? And do you have evidence that he knew that, such that it would arguably be intrinsic to this charged armed robbery?
To answer question number one, yes, they were going to stop him based on the grand jury warrant. As to question number two,
What you gonna say, Miss Hilton?
It appears, and I'm looking at text messages from his phone, and I don't know, all I can do is quote what I have, and these are text messages from November 8th of 2021.
Oh,
He said, "Just
November
wait till after
8th.
Christmas and the New Year, and turn
Over a
yourself
week
in, see what
later.
they're talking about."
All right, what? Okay, so, and the chase is November 30th, so this is several weeks before then.
Correct.
Okay.
And so the case went to grand jury on November 8th. The warrants were issued on November 15th. These are text messages he's receiving. And I want to make sure.
This is so stupid.
Yes, it appears that these are text messages from his girlfriend to him on November 8th. And she's saying to him, just wait till after Christmas and the New Year and turn yourself in, see what they're talking about. She says it might not be a lot of time. You think somebody's snitching on you.
About what? Are you sure that's
then
the
his
one that
response
you were
is, "I
talking
can't listen
about?
to the Christmas
No, you're
man."
not.
And then he goes in, "Yes, I don't want you to, but you can't run long either. That's going to make it worse. I'm lost. I don't know what to do." I would say to go to court, they might lock you up. He's like, "Yeah, but then they might not." So it appears from text messages, he was aware that the grand jury at least was going to, had indicted the case. Again, warrants weren't out yet, but at least that the grand jury had indicted the case.
This
because
is
those text
so
messages
vague
were
and so
from
stupid.
November 8th of 2021. So that's all the evidence that I would have.
All right,
outside.
well, I mean, given that he says, yeah, they might lock me up, maybe they won't. I don't think that, it's an argument to be made, but I think we're getting a little far afield of what's charged in this case. So I think I'm actually going to keep that particular incident out.
But I would just argue that he's fleeing from the armed robbery.
I know you're arguing that, but it's my ruling, so,
Thank you.
all right.
For you who don't remember it, in April, Miss Love screamed at Judge Glanville about his ruling. Screamed at him for minutes for him to change his mind. And the only way he got her to stop screaming at him was to bring in the jury, forcing her to sit down and not be see you next Tuesday. Miss Hilton has respect for this judge and sits down. And I don't think Miss Love is happy about it. Yeah. Yeah, by the way, I'm at Dave's place.
All
MLS
right, and with
blah, blah, blah.
regard to the two
I'm in
kind
the
of
treehouse.
post-indictment intrinsic acts, or arguably intrinsic acts, the stabbing in the jail and the exchange of the Percocet. I've watched the video now about the Percocet. I mean, I think that the state's rendition of what occurred is, pretty much on point. I can't hear what any.
That video of that handing over is not on point. Not in my opinion, but apparently the judge is of a different opinion.
Deputy says, but I don't think that there was anything particularly off about how they described what happened. I mean, I see what happens on the video. I've looked at some further case law, and I mean, how soon do y'all need to know what my ruling is on that? Because I'm kind of having the same thoughts about if we're talking about, whether these actually meet in any of the three requirements for intrinsic evidence. And then on top of that, 403, I'm just not real certain that these need to come in. I haven't made my final ruling.
Now, I do understand the judge. Because if she makes a wrong ruling and it turns out it's very important for the case, she will get so much crap for it. But at the other hand, if the state hasn't presented enough evidence and statutes and case law by now, why give them another chance? Why? I don't get it. Why?
Yeah, but I don't think that either of these is something that the state can't try the case without, which is not the only test, but I don't think they meet that test. So just kind of FYI on that, I'm having some,
Maybe offer some case law for the court.
sure.
We offer to the court an 11th Circuit case decided June 20th, 2024, United States versus Harding, HARDING. The site being 2024 US app, APE, Lexus 14995.
Okay, and what does it say?
Your Honor.
Or if you've got a copy of it, that's fine too, or I can just plug it in here.
And Harding, we do have a copy of it.
Okay.
And it's just standing for the proposition, generally that an act that occurs after the indictment can be included.
Yeah, okay. No, I've found my own cases that say that. Yeah, that's clear. It's not, post indictment does not bar it from being an intrinsic act. That law is pretty clear.
Right, Judge, and if I may, just very briefly, let me stand up.
That's all right. I mean, I
Voice is
got
just
it. It's
floating.
just-
I guess going back to the court's question in regards to how soon we need an answer from you in regards to that. I can't speak for the state. I'm not sure when they planned to try and present that evidence, but I would ask the court to continue giving it its full analysis, and especially in regards to the 403 and the overarching consideration as to whether or not they really need this particular piece of evidence to make out their case in chief. I don't believe that's the case, but I know that the court is wrestling with that. And I'll look at I don't know if I really need to look at the Harding case because we've already kind of established that that issue is not really an issue. But
Right.
I'll be happy to look for some additional case law. and
Okay,
send it to
thank
the
you. I
court.
appreciate it.
Your Honor, you had
Yes.
asked the
Who's
same,
talking
I'm
now?
sorry. Your Honor, you had asked the same of me. I have been pulling some case law, trying to put it together in a coherent presentation instead of just a list for Your Honor.
Okay, sure.
I definitely do want to take a look at this Harding case where it was found that the district court abused its discretion by admitting evidence as being intrinsic. So I certainly would like to take a look at that.
Okay,
So, Your Honor, in terms of other cases that talk about intrinsic evidence, we would just cite the court to Jennings versus the state, 318 Georgia, 579. And I am just giving a list right now that for the court's consideration. This is not something that we have to decide right now. This particular one is not coming up at all soon. The next case is Anderson versus the state, which is 313
Thank you,
Georgia,
Paris Rebus
178.
Show.
and what are these standing for?
These are all regarding the intrinsic evidence and how it is that one is, how one is to look at and determine whether evidence is intrinsic, broadly speaking.
Okay. Yeah, actually, US v. Harding, I'm pulling up what I put in my Lexis research folder this morning, and that's actually one of the cases that I was looking at this morning.
And the last one is Hughes versus the state, 312 Georgia, 149. And we too will present to the court a more coherent sort of
Okay.
overall arching
All right, appreciate it.
argument.
Okay. All right, so where do we want to turn now? What are y'all ready to talk about?
So Judge, if the court likes, we have reviewed we haven't discussed it with Mr. Williams' counsel, but we've reviewed and looked over the Brutin motion redactions. So I'll let counsel for defendant Williams speak to them, because this is, again, this is Mr. Kendrick's statement that is already in. There are portions that he is arguing are inadmissible because of Brutin. Our
Mhm.
position overall is that Brutin specifically requires that that a defendant be directly inculpated. And at these various points, I'll let them explain why they feel like someone is directly
Thank you,
inculpated
Kat.
so that I can respond, but we've reviewed them and whenever the courts.
All right, so is it the state's position then that none of the identified portions of Mr. Kendrick's statement actually qualify under Brutin?
No, there's one enumerated time
Okay.
area
Which one is that?
where, and they have it enumerated as,
And has anybody sent me that statement? I think I asked, but I'm not sure that I
Kendrick's statement?
Received it.
Mr. Kendrick's statement? the court
Yeah,
didn't
that's
receive?
the one at issue right now. Yes. And maybe you did. Obviously,
make
I'm
sure.
getting lots of emails through Ms. Persifield from all of y'all, but I don't recall seeing it.
How about that? Prosecution
Maybe somebody could just
unprepared.
send it now since
How
that's what
about
we'll be
that?
discussing. All right, so
Eh,
which is the one that you,
Everybody's shocked. Everybody's going, what? The prosecution came unprepared? Oh. I have words, but we are only 40 minutes in.
don't have an issue with?
It's the point at which the detectives ask Mr. Kendrick, who do you think did it? And
Okay,
Mr.
so he's actually broken them down into little Roman numerals. So which Roman numeral are we talking about?
I wrote at the bottom my own timestamp. It's at 10004. So that would be. Here it is. It's their number 8. Well, they're number 9 really, but they're number 8 specifically.
Detective Gaither mentions Mr. Stillwell, the one that is labeled that.
Right.
Oh.
Okay.
Well, it's labeled, I'm sorry, Mr. Kendrick mentions Mr.
Okay.
Stillwell telling detectives who they say
All right,
killed.
that's 8. But, okay, and you agree that that should be excised?
Partially because what happens is that this is the part that we would ask, that we specifically would argue is not inculpating anyone.
Okay.
What Mr. Kendrick says is they say our crew.
Uh-huh.
And he's in saying our crew, he's acknowledging that there is a crew. He said, because we're the ones beefing. And then they specifically say, who within your crew?
Uh-huh.
And at some point, Mr. Kendrick says, they say Shannon. That part we would agree comes out, but they didn't enumerate it exactly that way on this
Okay.
sheet of paper. So they say Shannon, we would agree comes out. He then says, they also say Woody, and then they say Shannon and Woody. So the part where he's naming people that they say did it beyond our crew, or people that Mr.
Uh-huh.
Kendrick identifies as.
So somebody says somebody told him Shannon and Woody. It's so stupid.
His crew, or, in acknowledging that there's a crew, we would argue that part, we would agree, concede that part definitely
All
comes
right.
out.
Okay, so you're saying that they say our crew isn't Brutin, but when it goes further to say, they say, whoever the they is, but they say Shannon, they say Woody, that part you agree?
Yes,
Can
I
be
would say
redacted.
that specifically it's
Okay.
Shannon comes
Shannon,
out.
they-
Yes.
Okay. All right, and every other one we're gonna need to look at.
And yes, I believe we should. look
Okay.
at the rest of them.
And has anybody come up with any case law about kind of the interplay between Brutin and a RICO or gang kind of charge? Okay. Okay, that's fine, as long as you're getting me something. They're two separate, well, not entirely separate, but I think we can do this without knowing the answer to that. Uh-huh.
If the state, if I heard correctly, if the state is not, over objection, by the way, intending to play the actual recording, then it's just question and answer. So I assume they're going to advise the witness, whomever the witness is, don't mention Mr. Williams, or if you're going to mention Mr. Williams, what are the specifics? Because otherwise we're just going through something that they may not answer the question.
Your Honor, if I may respond to that, I'm glad Mr. Steele brought that up, because as we were going through these last night, there are portions that I needed to bring to the court's attention that I need the jury to hear.
When the prosecution went through this last night, this is the preparation of this prosecution. They don't. They are forced to now by Judge Whittaker. But they more or less planned to bring this to the defense knowledge probably on the day of the testimony of incompetent Detective Gaither or Squirrel Brain Detective Thorpe, or whoever they plan to use. At what point, I've been saying this for weeks now, or months even in some cases. At what point do you hold the prosecution accountable? Remember, the prosecution said, we are ready for trial in November of 2022. Almost 2 years ago. And here they are claiming, oh, we went through it yesterday night, last night. It's hearsay 4 days.
Kendrick say. So we don't intend to play the video.
In
Right,
toto.
right.
Okay.
But there are portions that we would be introducing to have so that the jury hears him. And
Okay.
generally speaking, the overall method of introducing the majority of his statement would be through questions to avoid any implication of
Okay.
Brutin.
All right. Well, if there are particular portions that you know you intend to actually have the jury watch and listen to, if you can let the defense know which those are, that'll probably be helpful.
Okay.
Yeah, sure. So just let them know which of the portions, but okay, let's go through all of these if we need to, which it sounds like we need to.
Did you finish?
So do you want me to be, is there a transcript for this statement or do I need to be listening to the audio?
We don't have a transcript of this statement.
Okay.
But we can. I don't know how they want to do this. Since the defense has timestamps on it that are different than what we have, I think they may have downloaded it into an MP4 format, so it may be easier for them to play it from their format because I have a specific time. And
Sure. Mr. Steele, would you be able to play the video or the portions of the video that you want to litigate for us here so that I can know exactly what that says? Okay, that'd be great. Okay,
Yeah.
sure.
Can I just bring up another concern on
Uh-huh.
this subject? The concerns aren't limited to Brutin. I still like, we're talking about playing a tape where Mr. Kendrick says that other people are saying, he's not saying anything that he knows, he's not telling anyone, but he's saying other people are saying
Yeah,
that our crew and Shannon and Woody, and they're talking about taking Shannon's name out of it, which of course I'm in favor of, but I'm not even.
yeah, no, I agree.
I-
That's a little weird that the state's evidence would be, well, I mean, here's what the rumor on the street is.
Right.
So
Yep.
I.
How can
I bet Ms.
rumor on the
Phillips gonna
street
say we're
be
not
evidence in
intending to
trial?
Elicit that.
Exactly, Judge. The point is not, and we can tailor the questioning and the presentation of evidence to, not include.
It's not evidence. It's gossip on the town. It's like walking into a bingo parlor, sitting down next to a blue-haired lady and ask, what do you know about this?
Okay, well, I mean, I suspect the reason they're asking that now is because when we just went over that example, you thought that the only, and you may have just been saying the only part that I believe is Brutin is this part where somebody is specifically mentioned, and that's fair. But if you don't intend to use any of that portion of the tape anyway, or get a question and answer that would elicit that information, then it would be helpful if you would say that, because there's no point in us, spending time on something that the state doesn't intend to use anyway.
So to speak to that example, for instance, I might ask the detective a question that, did you talk to Mr. Kendrick about the Donovan Thomas murder?
Okay, that answer would be yes.
Yes. Did generally
Look at Doug. Oh, he's very interested now. Oh, he's so interested now. Okay, how are you going to get out of this one without an apparent hearsay objection?
speaking, what?
Let me ask you this. Do you think that it's relevant for the jury to hear that, Mr. Kendrick said, well, here's what the story on the street is right now?
No, that part I don't. I don't think that part about, the people on the street think XYZ is relevant. The relevant part is his acknowledgement that
Our crew.
Our
That
crew was
it's in-
beefing with them.
Okay.
There was a us and a them that was in conflict.
Okay, so then the only part of that then that you might elicit is that he acknowledged that at the time this all occurred, his crew was beefing with the other crew.
Yes.
Okay,
Thank you for actually.
all right, so when we're going through any,
But Judge, stop helping the prosecution. If the prosecution screws up, it's not your job to fix it. It is your job to make rulings between the defense and the prosecution based on what they present. And if Ms. Love is doing her buffering, don't unbuffer her. Let her stand there. Yeah, just let her stand there until she finds stuff out for her own.
these other ones, if there's something similar, just kind of let us know that, okay?
And Judge, we've just now sent to the court, we're sending to the court the October 6, 2015 interview. Does the court need the evidence reviewer player sent to it again?
So, no, I don't think so, but if we're gonna go by Mr. Steele's playing of it that has his timestamps, I guess I'll just watch that on Zoom. Are we? Mr. Steele? Okay. Okay.
And I don't want to belabor unnecessary points.
Mhm.
We are looking at it, and I was looking at this for the purpose of Brutin.
Right. Sure.
Sure you were. Sure you were, Miss Love. That's why you stood there buffering, not knowing what was going to happen. Thank you, 504 more. Meows or moo, meow. Sorry, 504. I'm in the treehouse drinking beer. Skip ahead. Through some dead air.
Nope.
That's the nice thing about recapping. I can skip parts. Dead air, I can play in 1.25. I can skip through pauses and breaks and comfort breaks. Makes it a little more digestible. Skip.
I mean, we're certainly gonna have to do that. I guess we can get started on that. Unless we're really close. 1 minute away. All right, we'll just hold for a minute.
Law
Or so.
Malcolm, there
Or
is
so.
no Mrs. Love.
Come on, Mr. Kokobo.
It's a
No
Miss
pressure.
Love because
Mr. Steele, how'd your oral argument go this morning?
upon information and belief and speculation, when everybody goes home after these proceedings, I mean, the defendants go to their jail, the defense attorneys goes to their families, so does most of the prosecution. I believe Miss Love goes home, attaches herself to the beam in the roof, and then sleeps like a bat.
The argument was good, but no one remembers the argument, so we'll see what the opinion is.
Okay. Yeah, sure. I mean, we might as well fill our time some way.
So it's in this courthouse. It says indictment on the cover. Second page has, typical indictment things, ways formal reading, et cetera. Third page has the grand jurors in Fulton County names. Then count 1 through count 6. Former district attorney Paul Howard does hereby charge the appellee with murder. Goes like that. So I didn't try the case. I did the appeal. The Honorable Judge Newkirk granted the motion for new trial, finding no jurisdiction because it was an accusation. So the Supreme Court was very lively. I mean,
Interesting.
It was an interesting case. And then it got so narrow. I was being asked, well, this is a novel issue. How would a lawyer know? You're saying it's deficient performance. How would a lawyer know? Yeah, I'm like, well, if I know, then anybody could know because I'm not that deep. So
Yeah.
that's what I said. But it was fascinating. It was intellectually similar.
Interesting.
And thank you for letting me attend.
Absolutely.
Yeah, they talked about Mr. Steele's oral argument against the Georgia Supreme Court.
Okay. We spent all that time on the wrong interview.
Okay, skip ahead.
All right, well, maybe we can turn to the PowerPoint issue and at least start making our way through that unless, are we ready now on the right?
Okay, remember when I talked about Ms. Love screaming at Judge Glanville? Judge Glanville actually said that is out. Now, I don't know why they are litigating this, unless Ms. Love somehow managed to make Judge Glanville unrule it out. I actually don't remember.
Okay. So we want October 6th, is that right? Okay.
Remember to hit the thumbs up and subscribe if you haven't subscribed yet. And if you are subscribed, please check again, because sometimes YouTube unsubscribes people. Thank you. Okay, skip. Oh, by the way, fun fact. You can all see Mr. Harvey. He's the tall guy in the back. I thought genuinely that he was taller than me. He's not. That's just me having fun. Well, let's skip forward until we get to the important part.
Lawyers and tech, they just don't mix.
Like lawyers and math. Don't
Hate
always.
to defend Mr. Kokomo here, but this is a lawyer issue, not a AV issue at this point.
Okay.
No, you're not, Dave. Dave is 4'8", and I believe they have a bonfire outside of the treehouse. And so when he hears this, he might put crackers in my bed tonight. No, he's not 4'8". He's not 4'8". He's 5'2". Maybe 4, maybe 6, maybe 8. Something. Yes, JMK, I'm just under 6'4", and I might be heavier than 280 because I've been driving across the United States and eating at restaurants and buffets and stuff. So I might be around 300 by the time I get home. Oh my! Miss Viking might put me on a
Ms. Love, I know
diet
you
when
said
I
the
get home.
state's timestamps were somewhat off, but can you get close? Maybe that's longer than we had anticipated.
Yeah, I thought so too, that Mr. Steele put the link to that ruling in a motion last week. Yeah. So she should be aware of it. And definitely Whitaker should be aware about Miss Love's conduct. If I tried anything near what Miss Love did, I wouldn't be practicing law. They would have verbally put an end to my career if I did what Miss Love did, screaming at a judge just because he ruled against her. All right, let's skip forward.
The numbers, the times that we are giving is based on the MP4 that was made from the evidence reviewer. So, and we can figure out how to convert that. But the 50 minutes, for instance, is not going to be 50 minutes on evidence reviewer.
Okay.
Jesus
All right.
Christ.
Well, thankfully, we've got the kind of general subject matter listed as well, so that'll help us.
You want this more? I assume we have to have this more. Somehow we can put on a thumb drive.
What we're playing now?
Yeah, but this case got, there's an appeal. Do you want just to know what we were looking at since we were saying?
Yeah, I mean, I agree with Michelle here. Says, I know why she let them argue admitting the PowerPoint. It was a learning moment for them. She basically said, no, they pushed, they learned the hard way. Yeah. Yeah, that's good. Paris River says, your Delphi hike reminded me of the absurdity of Zachariah carrying a 280-pound man wrapped in a rug. Yeah, for you who don't. Also, if you go back and watch my Zachariah Anderson case thing, the prosecution claimed that Zachariah at 6 foot 210 to 20, something around there, with a chronically bad back, took Rosalio Goiteres Jr., rolled him up in a rug. 280-pound man in a 5 foot by 7 foot rug. Rolled him into that. No droplets. No drag marks. Nothing. And carried him all the way out of the apartment through the entry. Opened the door to his family van, opened the family van, and put a 6 foot 280-pound man rolled up in a 5 foot by 7 foot rug into a 3 foot by 4 foot square in the back of the family van. Yeah. And he was still convicted. He was still convicted. Oh, yeah.
And we could do that.
Sure. Yeah, that's probably the easiest way to do it. So I guess this is the hearing on Mr. Williams' Brutin motion. Yeah. Yes. So this will just be defense exhibit 1 to the Williams Brutin motion concerning Mr. Kendrick's statements.
And we'll have that thumb drive today.
Thank you.
No, thank you.
Other people you associate with?
Okay.
Anybody?
Going through an interview. Well, yeah, I don't care about this. I don't care about this at all.
Williams to Mr. Kendrick, it wouldn't happen like that, but that's the first one.
Okay, well then maybe we can nip that one in the bud.
So there's, if Mr. Steele would not mind just letting that part play from 49
Okay.
so that we could.
It's 40 on here. When I got paid on bank here, they'll be when I got on call board, man, I'll leave my little boy right on.
This way, do you have any intention of who's this coming in through?
There would be either Detective Thorpe, probably Detective Thorpe later on.
Is he even in this?
He's
interview?
right there in front of you, to the left.
Oh, okay. I thought you had said Dennis and Gaither. but
Dennis and Gaither are sitting in front of Mr. Kendrick. And Detective Thorpe is to
Is
his
also
right.
in there.
He
Okay,
is.
all right.
There are three.
So, I mean, you're not going to ask Detective.
So Huey, Dewey, and Stewie was in the interrogation room. But amazingly, the one who is going to be on the stand barely is in frame. Isn't that interesting?
If Thorpe, if Gaither asked if Williams was a reason why.
No.
Okay, so
absolutely
that
not.
would be one then. This example would be one where you could say, we don't intend to ask that anyway.
Okay, so we do not intend to elicit or ask whether defendant Williams was
All right, well, let's
whatever.
circumvent spending the 5 minutes listening to it if you know you're not gonna use it anyway, okay? That would be super helpful. Okay, next.
But so when, again, this is one of those them, us, we, them situations. It is simply not one of those situations where we would be saying, you know, are they coming after y'all because of Thug? Are they coming after you because of we wouldn't be eliciting anything about another defendant. But if Mr. Kendrick is talking about a us and a them, like he is in this circumstance, they want to take my spot, things like that, then we would be putting that in. The reason I was saying we're looking at it in terms of Brutin is because if he's not talking about a defendant and he's not saying that person's name and inculpating him, then it's something that we will likely use. If there's a point at which I know that I'm just not going to even touch it, I'll do as the court has instructed though. If, and say, no, I wasn't even going to ask that anyway. It doesn't do us any good.
Okay, so then what I hear you saying is that while you're not going to elicit that somebody asked if Mr. Williams or Thug might be a reason people are after them, you would maybe ask about some part of Mr. Kendrick's answer there, which said something about whoever they is, wanting to take my spot.
Yes.
Okay.
And that we contend is not Brutin.
That would not be Brutin. Okay. Next.
5239, and it should be Detective Dennis speaking. And he talks about Mr. Shannon Stillwell. He calls him Shannon.
Okay. And then you wouldn't be able to mention Mr. Stillwell. Is there some part of this little bit? Go ahead.
I'm sorry.
Go ahead.
So he does not say that Mr. Stillwell bought the gun. He does not say anything that directly inculpates Mr. Stillwell. And my understanding is that Brutin does not prohibit the mentioning of.
Let me just hear it. I see this is the way it's going to go.
Playing from 5214.
Yeah. I'm going to skip ahead.
Nothing to do with Miss Hilton told me to buy the gun.
Well, I mean, unless you can make it really clear that all that's doing is orienting him in time to something, but to have the question be in front of the jury that is, okay, you had this gun that you got in trouble for. Did you buy it after you talked to one of your co-defendants? Just seems too Brutin-ish to me to permit it. And the state ought to want to try a clean case.
Me too.
So
That's fine. We don't have to
would not
keep
be
that
clean.
in. Okay.
Go ahead. Next one.
Okay. I can skip through that.
250. You should back it up. To Dennis's voice, who's mentioned Mr. Stillwell swung first outside a club Crucial. That's the fight that you've been hearing about on the 6th day of January, 2015.
Well, I might not even need to hear that one.
Your Honor, just before we go to that one, I just want to make clear, Mr. Stillwell's name is the only one that is on trial that Mr. Kendrick mentions at the last little clip. Mr. Copeland, Mr. Arnold, Mr. Lamar, they have those names listed in their motion. I'm sure they don't intend that. That is a Brutin violation. They're not on trial. So we would.
Yeah, Bahira, the term buffering I'm borrowing from Kat, not Williams, because they came up with that in her chat, I believe. And I'm borrowing it because, as you said, it describes her behavior. She's just abba. Yep. Buffering. Let's continue.
We would believe that it's okay to mention those names. But
Does the defense want to be heard at all on that, or what your position is on that?
I'm still researching, Your Honor,
How did y'all redact this indictment? In
I've
that
been
way?
asking that
You say
it's been denied.
Well, what got read to the jury at the beginning?
Everything except, I think, overt act 26 maybe was redacted, maybe 2 overt acts, but I have to check my notes on which ones. Otherwise, the entirety of the indictment was read to the jury.
Including the names of all of the co-defendants that are not on trial?
Yes, every one of them.
Your Honor, at the time, they were on trial. So severance happened during the course. So when we first had the indictment read, it was more than just the 6 that are
Was it
present in the
all,
court.
whatever, 19 of them?
with the exception of maybe
Yeah.
the ones that hadn't yet been apprehended.
Yeah, so everyone was here except for,
And everybody at that point in time was on trial together?
Yeah.
I mean, it's been a long time.
Except for the ones that pled and a few that were not apprehended, yes.
The ones that had not had attorney. Some that had not been apprehended.
So, did you catch that, folks? Some of them who did not have an attorney. For you who don't know, up until this trial started, there were people in the co-conspirators, defendants, whatevers, had still not. I believe the last bond hearing was just a few days before this trial started because there were no defense attorneys enough to represent them. Up until this trial started, a handful of people were still in jail, unindicted, because they had no representation. But here we are, with the trial still going.
So there were, I
So,
think 6 that weren't.
so Mr. Kitchens is indicted. He pled guilty around Thanksgiving of 2023. The jury first came upon us January 4th, 2023. So I made a mistake. Mr. Kitchens pled guilty under Alford in November of 2022. Mr. Arnold did the same. Mr. Sumlin did the same. Mr. Stevens did the same. Mr. Murphy did the same. Mr. Sledge did the same. Thank you. And I should look at the indictment for more. Mr. Garlington never had a lawyer, so he was already removed. Mr. Wani Lee pled guilty around the same time.
That last one?
Mr. Wani Lee, L-E-E,
Oh, okay.
and Wani is W-U-N-N-I-E.
Yeah.
So, the stage, I'm sure it was a miscalculation, but these people were already all included in everything in the indictment, but were not on trial before the veneer panel was first put upon us. And if I left somebody out, Mr. Eppinger was with us for jury selection, then he got, something happened, and he got removed after that, so he was in a different category. Mr. Blaylock pled guilty after the veneer panel.
Mr. Blaylock has not pled guilty. Mr. Blaylock was severed as well. So I believe I said everyone who had not pled and not been arrested was present. So there were individuals who were severed subsequently. So Mr. Blaylock was severed after the jury was impaneled.
That's true.
Mr. Dorsey was severed. Ms. Eppinger was severed. Mr. Minder was severed after the jury was impaneled.
Right. So the people I mentioned pled before the veneer panel was read the indictment. And I'll look at the indictment. There may be a couple more, but that's my memory.
This is quite important, but this tells the judge that the foul play has been there all along.
Mr. Winfrey was severed before we did, he was apprehended, I think, afterwards. So name was read to the jury, but he was never with us.
So if they had not pled and they had been arrested, they were all on trial. And so obviously those names were read. Were the names of the people who hadn't been arrested and hadn't pled been read? Were they read? So everybody's name was read. Okay.
Yeah, that's not good. Because that,
And
listen to the judge, her sound here.
so everybody's name was read. Okay.
That was intentional. She did not like this at all, because this is kind of a huge deal, folks. This is kind of a huge deal. To this panel, names who were not arrested, names were read that shouldn't have been. And why? Because the state don't care. That is kind of a big deal and an appellate issue if it comes to it.
And I don't know if there were any counts of the was every count of the indictment read? Even if it was only against somebody who had already pled?
Yes, Your Honor, because I think it was pre-recorded, and so everything was read. I think it's your question, yes.
Okay. Was there any objection to that? Okay.
Yeah.
There's objection to that, and there's a yes, to get clarity, because on the yes.
I mean, honestly, at this point, that'll be a motion for new trial issue if it gets to that stage. I'm just trying to figure out what this jury has heard.
Yeah.
Y'all would not intend to send out an unredacted indictment if we get to deliberation, right?
We had actually talked about redacting the indictment. I think we were
Okay,
actually,
all right, well, good, because I don't think an unredacted one should go out. All right, anyway, back to what we were doing,
An unredacted indictment shouldn't have been read to this jury. And it was. And as the judge just explained, that is a motion for a new trial, right there. Or an appellate issue, motioning for a new trial.
so I mean, the question was, with regard to people who are not on trial here now with these 6, is there any kind of objection to those people being mentioned?
Yes, so I'm finding Brutin under conspiracy
Yeah,
and directly impact, and that's what I have to get to the. court.
okay, all right, well, why don't we circle back on this one then? Because that, obviously what the law is will determine what the answer is.
Yeah.
So it's definitely out with regard to naming anybody on trial here other than Mr. Kendrick, but with regard to anybody else, TBD, depending upon what the law says about that.
yes, Your Honor.
Okay. So y'all get the next one lined up. Let me jot myself a note on that.
Yes, the defense did initially object to everybody, every indictment and every name being read into the record.
Okay, I'm ready for the next one.
Hi, Kat. Let's.
Woody got jumped on. There's a discussion of where is TIG. Then Detective Gaither says Metropolitan, like over there by Thug Studio. Mr. Kendrick asks, where's Thug Studio at? And then they talk about that location. They talk about YF and Lucy. And then at 103, Detective Dennis say, you still on Bloody J when he got locked up, and it goes on to that event. And
So is this just because Mr. Williams' studio is mentioned to
Well,
orient people to where things are?
well, at 102, it's just about the studio, but I was targeting the RICO conspiracy. So I was targeting the, this is where,
I need to take a visit on the big boys room, but I will be listening in while this plays. I'll be right back.
actually, I'll withdraw that because
Okay.
it does not mention, I apologize.
All right, no problem.
All right, number 105:19, 1:05:19, Detective Dennis mentions Mr. Williams' quote unquote girl regarding a shooting, supposed shooting of that event. And that is it's 104:32. Detective Dennis states, didn't you catch them down bad? That's a reference to Mr. Kendrick's music. They laugh. It's a verse in a song. And then Detective Dennis says, so who shot up Thug's Girls event? Or did you hear about that? And Mr. Kendrick says, I don't know. That's my first time hearing about it, so I wanted that excluded.
What's the response?
Doesn't, number one, evidence of that has already come in through Dennis, but number two, that in no way inculpates Mr. Williams in anything because it references
His
him as-
girl being a victim.
right.
Okay, yeah, I mean, I don't think that's a Brutin issue.
So my issue with that then would fall back on a different issue then. What's the point? The answer is, I don't know anything about it. So we're now just using
So
the
now we have
question.
a relevance objection. No, we'll do them all at the same time, so
So,
we don't.
I don't have a problem not having him since he doesn't know anything about it, keeping that part out. He said, I don't know
Okay.
about that. I don't have any problem keeping
All
that
right,
part out.
thank you.
Next is 108, 1:08:40. And this is the part you heard earlier that may be stipulated to. Mr. Kendrick mentions Mr. Stillwell telling detectives who quote unquote they.
Right, and on that one, what would be permissible to ask about is that at around this time,
They were beefing. with
our crew were beefing with
them.
the other group, but not anything about the rumors or anything like that. So that one I think is clear. Okay. Next one.
The next, Your Honor, will be it's really the same flow, but it's 108:51, so it's only 11 seconds later. And Mr. Kendrick, excuse me, mentions Mr. Copeland sharing that he was tied up with Mr. Stillwell and specifically, and then Mr. Kendrick identifies a photograph 8 seconds later of Mr. Stillwell. Then Detective Thorpe mentions Mr. Stillwell and clarifies that the word is that Mr. Stillwell and Mr. Copeland killed Mr. Thomas. And Mr. Kendrick speaks to that.
We don't have any intent to bring that out.
Any of that?
Right.
Okay.
That-
Okay, the next is 1:11:30. And it's Detective Gaither mentioning that Mr. Stillwell is the person that everyone, whoever everyone is, brings up related to the murder of Mr. Thomas.
And this falls in with what we initially said, that when they were talking about who they said killed Donovan and bringing up Mr. Stillwell's name, we have no intention of doing any of that.
Okay.
The next one is 1:13:44. And it's Detective Thorpe, I believe.
All right.
And he says, people talk to you in the city, I'll put you four involved in the murder of some kind. Mr. Kendrick denies it, says they are lying. Detective Gaither says, you think anybody going to tell the same story? Mr. Kendrick asks, what did they tell? Detective Gaither said, I heard you was in the car. Mr. Kendrick said, what car? Detective Gaither said, the Infinity rental from Thug. And then Mr. Kendrick said, no, I wasn't. Check whatever, my phone, whatever you want to check. And then Detective Gaither says, we did, it was said a whole lot. And then they go off on that. So I was objecting to Mr. Williams or Thug you
That-
mentioned.
Your Honor, that whole, all of that colloquy is part and parcel of them talking about who people said killed Donovan Thomas. Anytime we're talking about any of these defendants being rumored to have killed Donovan Thomas, the state has no plans to get near that part. Now, Mr. Kendrick denying that he was in a rental by Mr. Williams, we would proffer that type of information because it would not inculpate Mr. Williams.
Yeah, I agree with that. I mean, I think it's already in evidence that Mr. Williams rented an Infinity, right?
Yes.
And it's up for dispute whether that was involved or not,
Right.
but say.
Sorry, I forgot. Sorry. Darn it. Yeah, okay. Up with the boomer emojis. What I was saying, yeah, about this Infinity. The prosecution apparently is going to present somebody who says, yes, that is an Infinity. I said it the day of that surveillance video and the so-called drive-by, that light-colored car. That's not an Infinity. That's not an infinity. Because the grill does not match an infinity. It doesn't match the other car the state alleges was involved in this. You can all go back and watch it. Simply because in those few frames where you can actually see the front of the drive-by car, the grille is horizontal. Infinity does not have horizontal bars on the grille. Neither does the other car. It might look like an infinity, but the grille does not match. In my opinion, you can call me a blind bat if you want to, but in my opinion, that car is not an infinity.
And, you know, the infinity that he rented doesn't inculpate him directly. So that I would be okay with. I mean, I don't think there's a Brutin violation if you ask or get an answer that talks about the infinity that Mr. Williams rented or that Thug rented. Okay.
The next, and I'm skipping based upon what the state just said.
Yes, skillet pan. If the grill does not fit, you must acquit. Oh, that's a good one. Thank you, skillet pan.
About that whole colloquy.
Okay.
So it would go to 1:18:31. And that's after 1:17:35. Mr. Kendrick reaffirms he has nothing to do with the murder of Mr. Thomas. And then at 1:18:25, Detective Gaither asks about NARD, NARD, and DUOP, DUWOP, where they are now. And Mr. Kendrick explains he's almost questioningly locked up. And then the target event, Your Honor, is Detective Gaither asked from January 10th until today, how many times do you think Shannon been locked up? We'd like that redacted.
My apologies for leaving that out. I would not put that in.
Okay.
Okay. The next one.
The part about Mr. Stillwell being locked up, the other
Right.
part, yeah.
Yeah.
The next one is 1:21:25, Your Honor. And at that point, Mr. Kendrick had shared with the detectives that he went to Miami after January 10th. Detective Dennis asked who all went. The answer by Mr. Kendrick is everybody. Detective Gaither said, who is everybody? And then Mr. Kendrick starts naming little d, everybody. And then Detective Dennis points to the photograph of Shannon Stillwell. Mr. Kendrick says, yes. Says, yeah, actually, Y-E-A-H.
Okay.
So that's the part that we were taking out the picture and the pointing.
Well,
This is just him saying, here's who all went to Miami.
Yes,
That
immediately after.
doesn't
the,
inculpate anybody directly in anything. It might be argued to be a part of the evidence, but that wouldn't be a Brutin violation.
Okay, we're just raising objections then, if that's okay. And when I say okay, I'm not waiving anything.
I understand.
Okay, thank you. I said okay, but thank you.
Yeah.
All right, the next one is going to be included. Did Thug went? Was a question by Detective Gaither. The answer is yes or yeah. So I assume it's the same ruling.
Yeah.
The next one, Your Honor, would be, and I assume it's covered by your ruling. Detective Gaither asked Mr. Kendrick, how long did Mr. Williams stay in Miami? So I'm assuming it's the same ruling. So I'm moving on from that one.
Okay. So the one about before that 1.23.06 about Mr. Stillwell getting calls.
Yes, I should have included,
That
I
doesn't-
skipped that one accidentally.
And what'd you say, Ms. Love?
I'll let the court decide on that. I'll let the court hear that because I didn't count that as inculpating because everybody was, what he's contending is that people were calling, but I'll have to hear that part again.
Okay, let's just
because
hear that part because I'm not sure what it says. And
Started about 1:22:40, if you can, Mr.
Okay.
Kokomo. And what it should say is, it should be Detective Dennis
Okay.
asking about what conversation was like on the way down to Miami. Detective Dennis specifically, I believe, said, Your Honor, the ride down had to be some type of, just like you just said, like when Duke got jumped on, people started hitting your line. So you all started to get worried and Mr. Kendrick said, it wasn't on my conscience. And then in there, they talk about Mrs. Stillwell was probably getting calls.
all right, let's just see.
I know conversation. Everybody just sitting there like, yeah, that was just stoned with. Like, I get my own strong heart. So. Right. What I'm saying is,
Yeah. Thank you, John Commune, for your $5 super chat. What is your favorite ABBA song and why is it Dancing Queen? I can't say I have a favorite ABBA song, but well, sure. But thank you for your support, young commune. Thank you. I'm not a pop kind of guy. I'm more into the death metal grindcore scenery. Yeah. But thank you. Let's skip the video because it's not interesting for me at least.
Yeah, you know what I'm saying? They want, but if they
We wouldn't have any problem taking that whole last 2 or 3 sentences out. Like, they were probably getting calls thinking it was them, and then Dennis saying, well, it's your people, you guilty by association. Like that, those 3 or 4 lines, we don't have any problem coming out.
All right, does that cover it?
Yeah, Mr. Kendrick, I'm sure it covers it, specifically said Shannon, so I'm assuming that's it covered it too.
Let's make sure.
Yes,
Okay.
yes, yes.
Okay,
Excuse me, Your Honor. Can we take 5 minutes before we continue down the list?
sure. Yeah, that's fine. Let's take a quick break.
Thank you.
Sure.
Let's skip ahead. That is more than 5 minutes. And the law and C word is starting without sound as per usual.
I believe it's including the next one, Your Honor. We are going to, I believe it's including your honorable court's ruling. It's approximately 1:25:39. Detective Gaither asked Mr. Kendrick how long Mr. Williams was in Miami, and he answers.
Yeah. Unless you put big question marks in front of it, I don't really spot it. Yes, I know it's not a big chat, but let me go insane. Dun, dun, dun. Scrolling up. There. If the judge hasn't had the chance to read all of the previous testimony and rulings, how can she even rule on things? That was handled more or less on the first day that she didn't plan to reverse any rulings. And she is taking over the trial from that day going forward. But I kind of agree, because if you don't know the history, how can you make correct rulings on what's going on forward? I do agree on that. All right. Let's keep going.
Couple of weeks, so I assume that your court said that that's not inculpatory, so I'm moving on.
All right,
The next one is, it's a visual, so if they're
Okay.
not showing the video at this, it won't matter.
all right.
But Detective Dennis points to the photograph of Mr. Stillwell and says he's all about that action, and they're talking about shooting people. They're talking about violence. So you may have to hear that, but and see it, but we would object to that.
You're not going to use that? All right, states agrees. Well, they don't agree it's proven, but they're not going to be using it.
Okay. The next one,
There's a lot
Detective
going
Thorpe.
out.
It's a 1:33:55. Mentions Mr. Williams and how Detective Thorpe heard that people went to Mr. Williams' home after the killing of Donovan Thomas. You may have ruled because of the way you treated the rental car that's not Brutin, but that's what I flagged.
All right. Do you think I need to hear it, or is it pretty much?
That's pretty much it.
Okay, yep, that would not be Brutin.
The next one is approximately 1:43:20. And I'm not so sure this is covered by Brutin, but Detective Gaither asked Mr. Stillwell if he drives a Volkswagen, but I flagged it. But if that's not directly inculpatory, I understand that, but that's what is said.
Okay, and this is just, does Mr. Stillwell or his nickname drive a Volkswagen? Yeah.
Yes. The next one is 1:47:18. Detective Gaither asks what was in its, I said Mr. Williams, but Thug's demeanor when he pulled up to the McDonald's, and Mr. Kendrick says he cannot speak on that. So I assume that that's not under this honorable court's ruling, anything we deal with Brutin. So I'm moving on.
Okay.
And if I'm waiving
No,
something, you
you
say
are,
no.
you are correct
Okay.
in your assumption.
And then the next one is 1:48:07. Detective Gaither asks, so that night, meaning the killing, you didn't meet up with Mr. Williams, and then ask the same for Mr. Stillwell based upon your honorable court's ruling. I believe that then we're going to skip. And if I'm wrong, please tell me I'm wrong, but
Does, what's the state's intention with regard to anything you might ask about that?
Given his alibi, we would, well, I don't know what, we would probably be
Asking that. Okay, well, yeah, I mean, I think that would be okay.
And then the next one is two. Well, it's really the same, Your Honor. It's clarifying the same thing. Did you meet up with Mr. Williams or Thug and Mr. Stillwell? So
Okay,
that's
Yeah,
it. That would
same.
cover the entirety. Now, that's just for Bruton, but again, I will send to the Honorable Court, and there are cases on a RICO conspiracy, a conspiracy, and Bruton.
okay, I'll be on the lookout for that and the state's position on that also. To going through the evidence that's going to come in with the next few witnesses, including Mr. Sprinkle. If y'all are ready on that, we can move on to the wiretap evidence that the state intends to use. We can,
The PowerPoint maybe is.
I mean, we can do the PowerPoint. Would the wiretap evidence come before the PowerPoint?
No.
in-
it would
Okay,
come after the
PowerPoint. All right, yeah, we can look at that. So everybody should have,
This one is a great. I'm glad I caught that one. Why does free speech not apply to Thug? Because the prosecution alleges that the lyrics are admissions. They are referencing actual crimes. And what is interesting about that argument, and this has been brought up in this court, is that only rap lyrics are considered evidence or have ever been brought up as possible evidence of crimes, which is quite interesting because you have interesting melodies and tunes regarding inappropriate actions with teenagers. There's a lot of song lyrics about weird stuff. And then when you go into the more obscure kinds of metal, like black metal, they talk a great deal, especially the Norwegian black metal scene back in the late 80s, described the burning of churches. And that was still in a Norwegian court not admissible as evidence because lyrics aren't evidence of anything. They are just lyrics, even if it's more or less word by word, here is how we did it. That is the at least Norwegian and Swedish interpretation of the free speech statutes, but not in the United States. Now, there have been a case in the Georgia Supreme Court about lyrics and videos, where they more or less tells the prosecutions in Georgia, be really careful, because if this comes up to us and it's not good, we might reverse. That decision happened in, I believe it was February of this year. All right. Good question. Thank you so much. Glad I caught it.
kind of revised PowerPoint, I guess, that the state provided over the weekend, I think.
Easily run through it.
Yeah.
And Your Honor, if I may just turn my back. You will get the thumb drive to Chris Winter. Yes.
And so what the state sent over at this point would be, y'all have taken out everything that you don't intend to use. So the hope is for y'all that all of what you provided is usable, and we'll sort that out. All right. Yeah, so if somebody wouldn't mind, I guess, just giving us kind of a slide by slide.
Let me just give you a quick example of a song from 1977, I believe. It's a song by Kiss, and it's called Christine 16. Yeah, and at the time of that song being released, I believe Gene Simmons was close to it was in his late 20s at least. And we'll leave it at that.
And I don't know that it needs to be displayed on Zoom as long as we're all looking at the same thing. That might be a better approach. So let's all just get our email that send it over and open it up and look at the slides on our personal computers or laptops.
It was sent Sunday at 9:15.
And was it a Dropbox link or was it an attachment?
It was an attachment with a PDF.
Okay. Right. Okay. Get up. Yes, yes, yes. Okay. All right. Slide 1, I don't see how the state could possibly need that slide.
Oh, they're going into the slideshow. Yeah, this is interesting because she did allow the prosecution to try to argue this PDF thingy they wanted to present to the jury.
No, that's not. No, I mean, it's not.
Okay. Slide 1's out. Slide 2. What, this is just sort of,
These are identifiers that identifiers that APD has identified, and
all right, hadn't there already been testimony about that?
there has been testimony about snakes and tattoos and red flags. Yes,
Okay, so that one's out too.
if you say it is, it is.
Huh?
And
I mean,
just to make sure we're all on the same page, what you're referring to as slide number 2 is the picture that has an arm with a
Yeah.
tattoo. Okay.
Yeah.
Which also coincidentally is the second slide in the attachment. That's what I'm going by.
All right. Just didn't want to make sure you weren't
All
looking at the title page. And everything.
Okay.
We're on the same page,
All right.
literally.
Okay, good. All right. Slide number 3. What's y'all's argument for needing that?
Okay, we can.
Because we've still got some language on all of this too.
So we can take out, well, we can take out all the language.
Mm-hmm.
We take out all the language.
Okay.
Can you take that? John, may we, be allowed to remove the Mondo board, the IT department?
Yes, that would be wonderful. We're not going to use it, so out it goes. So
Thank
y'all go ahead and, yeah.
Not right now.
Okay. What about these 5 pictures?
So the pictures, Judge, are just, as he's talking, he would,
All right. So who are the, I see we've got
Defendant Williams,
Mr. Williams, Rich Homie Kwan.
Birmingham.
Are there pictures already in evidence of
Yes.
those 3 people?
Yes.
Then use the pictures already in evidence. How about the bottom 2? Who are they?
Donovan Thomas is on the far right side.
Is there a picture of him already in evidence?
Yes.
There is a picture of him in evidence.
All right, use that. What's the middle 5th one?
And this is Defendant Williams. And
Hey, Kat. Yeah, she said she redacted. What did she redact? My argument is she only said she redacted. She didn't actually redact anything from this. So they're going one by one. One by one.
as
Sarah,
pre the gang, pre the dispute, the war,
okay. Is there a picture similar to that if he needs to identify people or a group of people he could use?
Yes. Numerous.
Hold on 1 second, Your Honor.
Oh, there are so many pictures in already. This is
Have
cumulative.
videos of the groups. Of
All right, so
persons
you could do a
together.
still from a video.
We
Okay,
can.
all right, how about slide 4?
This is just, Your Honor, and our position regarding the displaying of these pictures is that they're demonstrative as he's talking about them. Of course, they've seen Mr. Copeland for what feels like ever. So they sort of know who he is.
Mhm.
They haven't seen as many pictures, just face shots of Mr. Watts. So they're not, we would just put forth that
Is there a picture of Mr. Watts in evidence?
Yes,
but
there
they're
is.
Looks
demonstrative.
kind of similar to this.
So the reason that we would ask that the PowerPoint photos be allowed to be kept in is they're demonstrative. These are clear face shots of who they are talking about. There's nothing that is inherently or substantially more prejudicial due to the cumulative nature of these photographs that cause either defendant to be in danger of being convicted of something or on something other than proof of the crimes we have listed in the
Are they
indictment.
going to, for some reason, be talking about Mr. Copeland and Mr. Watts together, that they're like,
Yes.
it's going to be crucial for the jury to see, here's Copeland and here's Watts?
Not crucial. But he will be talking about a specific interaction, specific.
Okay, well, he can
antagonist.
talk about that without this, and if you need to like have the jury reminded, oh, this is what Mr. Watts looks like or something, just use something already in evidence. All right, what's this picture of some fence?
The gambling house that
Do we have pictures already in evidence of that?
knew.
Okay, then this one's fine. Slide 6. With the stack of money and obscene gesture.
Hold on. Well, that's Mr. Copeland, and it was that stack of money and that flashing of it at a club that led to the conflict between him and Mr. Watts. So
Okay,
We've also got video of him doing exactly the same thing.
we don't have that video.
Yes, we do. We've got a video and
all
trace
right,
of
well,
him.
don't talk over each other. Do you know what exhibit number that is?
Your Honor, we initially entered the video in June. However, that was after 3 o'clock. And so we did not enter
Ah,
it again
Okay.
this time around. So I do not believe the video was in evidence. I'll double check,
Okay.
but I believe that was after
All
3
right.
o'clock.
Actually, a good point there, because we do need to make sure when we're finally reviewing what evidence is in and out, that we make sure that everything that was entered in that little period of time is unentered, if you will. So, okay, this one's fine. He can use this one.
Can I inquire as to exactly what the relevance would be of showing a picture of Mr. Copeland holding money and flashing the bird?
Well, I mean, they said that was what had started a beef between him and Watts,
The flashing of the large sums of money.
not the flipping the bird.
I mean, I don't.
Yes, no?
The flipping the bird, I mean, it wouldn't have, our argument is that it's relevant because it shows Mr. Copeland with that huge stack of money that we're talking about, and it makes,
Is this the night of,
it's,
or is this
you
just?
say the night of, not
The
Donovan
night-
Thomas.
No, the night that the beef starts between he and Watts.
No, Your Honor, it is not.
It's just an example of him with a
Flipping the
bunch of
bird,
money.
holding money.
An exemplar,
It-
good
it's-
word.
I think it's January 8th,
So
the 6th, January.
So it doesn't have anything to do with the alleged beef. It's just Woody with cash flipping the bird.
the 6th. So it was the night, it preceded it. That's the night that the fight started that led to the arrest of, I think, Mr. Kendrick and Mr. Arnold the first time when Bloody James punched out.
So this is a picture from the night that, it all got shot up or something?
I'll confirm, but that's what
After-
my understanding, that is January the 6th.
How do we know it's January 6th? Where does that date?
I don't know. I don't know, maybe they know what he was wearing to the
It's
club
the
that night.
detective that gave it to us, so.
My recollection is that he had different clothes on the night when he was flashing the money than he does in this particular picture. I do not believe.
So do you have any kind of picture from that? I mean, if you can confirm it was that night,
We
that's
will.
fine. Otherwise, it's just an example of, hey,
Well, not just,
here's what we mean about flashing money.
no, the large amounts of money.
Right.
I think during the course of the interviews that the jury has heard, you hear them talking about a very, very large sum of money.
Right.
And, one might argue or wonder, what kind of money, how much money did he have access to that kind of money? Him having
Oh, for 1 hour 48. Let's wait a few more minutes before those words. But seriously, Copeland on the stand is talking about a large sum of money. And they need to show a large... Seriously? This is so stupid.
having a stack of money like this. I mean, it could have all been ones, but even ones would have been a lot. I mean, I'm just saying. So the relevance bar is, of course, as the court knows, is a low
Yeah.
bar. And the fact that he's sitting there with that.
Okay. Well, he also is flashing the bird though, or flipping the bird. So that's a little bit offensive, I'm sure, to some of the jurors. So maybe why don't you find out whether A, this is that night, and B, if there's some other photo already in evidence with him with large stacks of money, okay? So we'll revisit that when we've got some more info.
Yes, Your Honor.
All right, slide 7. This just shows a couple of the,
No.
I mean, the metro, but y'all, there's been testimony about the Metropolitan.
By the way, good news. I revisited my ticket back from United States to Sweden. That leaves Saturday evening, which means this Friday will be a proper Friday panel show with a new kind of Wheel of Regrets, because I don't need to go anywhere in the morning. So be prepared, folks.
Right. TIG studios that
Right.
Mr. Copeland is alleged to have shot up or believed to have shot up.
We've had a number of crime scene photos ended of the Metropolitan. So there are a number of photos of that in already.
So it doesn't, there's nothing, if Detective Dennis is talking about this, putting it up doesn't take extra time. It just orients the jury as to what he's talking about. So it's a demonstrative aid that
Demonstrative
orients the
aid.
jury, that is helpful to the jury, that is substantially similar to what that is exactly what he's talking about. So there's nothing that should preclude
Okay,
him from
and
showing it to the jury.
TIG is who's,
Think It's a Game is
Right,
the company that Rich Homie Quan was under, that Think It's a Game Studios is inside
Right.
that building right there.
okay. This one's fine.
Oh,
All right, moving on to slide 8.
question for you guys. It appears like most of these demonstratives and stuff is about Woody starting things and Woody doing crimes. How will that affect the jury knowing that the prosecution gave him immunity? Just saying. I think this will look poorly for the prosecution when they are pushing all this bad stuff on Woody and then giving him immunity. You tell me. You tell me.
So this is several pictures of Mr. Thomas. We definitely do not need the Club Crucial Will Always Remember You part of that.
Okay.
And, you know, the language about whether he's a high-ranking member of a rival gang, I mean,
It can come out.
thank you.
But yeah.
I know it's asserted that he is, but this sets it forth like
Yes. it can-
fact, and
it-
that's for the jury to determine.
Yes, Your Honor. I'm just trying to X over everything.
Okay, so,
Did you have something?
I mean, those 3 pictures basically of Mr. Thomas and Mr. Thomas and some of his
Brothers, family,
Well,
whomever.
I would object to the pictures of,
grief.
well, the pictures period. I mean, I don't know what the relevance is or what a jury would need or how this would aid the jury in understanding any testimony from Detective Dennis to show pictures of him and various individuals just standing around.
So, do you want to elucidate us on that?
Yes, we can take.
Okay, so they won't use that one. All right, slide 9.
Come on, Miss Love, show your
So
incompetence.
slide 9 shows just the type of,
Are these actual posts already in evidence?
no, we did not.
Okay, well, if they're not, then I would think if you throw these up, that is more than demonstrative. So if
Exactly.
you want to enter those as examples, we can talk
Okay.
about that, but
Okay.
otherwise he could just testify that here's what happened on social media after the death.
Okay.
All right, slide 10.
Your Honor,
Yeah,
I would be objecting to Detective Dennis saying this is what I saw on social. Okay, you understand that?
okay.
would
And
be hearsay.
because, and how would, well, No, what he saw on social media, he saw on social media.
If he's going to say, I saw on social media and someone posted the following, I'm assuming that's for the truth of the matter asserted. And the post should not come in. I don't know who posted it. It would have to lay a foundation for the writing.
So the fact that the posts were made and that they were publicly made is part of, is the evidence itself, not that it's true. This death to the big homie sent the word out from behind the wall.
What would you have the answer generally be? I mean, what would you presume his answer would be, or your question and his answer?
Were there threats made against YSL in the moments, hours, days following Donovan Thomas's murder? Yes, there were public threats, social media posts, and the like, and these would be them.
Okay, well, that would. Okay, and that would be overruled because it isn't being offered for its truth. Okay, but we can just do that at the point in trial. We don't have to have this slide.
Okay.
Slides out.
Slides out. All
Slide
right,
out.
slide 10. To me, I
I'm
guess what
enjoying
looking at
this.
and why
Seeing
he's
Love
using this.
humbled. Well, Miss Love doesn't know humble.
We can take this out. I think that this picture is already in any event.
All right. Slide 11. There's a lot going on this slide.
There he is. He can testify about that. It's basically it's Mr. It's the services of the victim in this case. So he can testify about it.
It's a good
It's
question.
victim impact.
What would be the
Just-
relevance of how, many people were moved by his death?
Judge, if I may,
Because Donovan Thomas' dad was allowed to do a victim's statement, victim's impact statement during his testimony, and now they want to bring in more. Now I feel for Donovan Thomas' dad, but he should blame the prosecution at the time and the investigators who fumbled the ball so bad that Mr. Sprinkle twice recommended the charges be dismissed. And they were.
come back to the court on that. I can take out the slide and
Okay,
as to the questions about it.
all right.
So 11's out.
So the slide, yes, 11 is not going to be used, and she'll get back to me on the relevance of how crowded his funeral was.
He's very loved.
And maybe it is, I don't know.
But what's the relevance?
All right, slide 12. So how about slide 12?
We can take out that. It's a similar one as the one earlier, so we can take out, we can take that out in the same way and introduce it if we need to. and-
Okay. Thank you.
$12 out. 13. Come on.
Is the picture with the placards from obviously some shooting already in evidence?
I don't think this particular one is, but it will be. We anticipate that this will be
Okay,
admitted in
well,
evidence.
if you want to present it to him and ask him about it, that's fine.
Okay.
And the second one on there, do y'all intend to have him talk about that picture?
We can take that out.
Okay, all right. So then 13 essentially won't be used, and you can, if he can identify what's the crime scene photo.
Yes,
then
this
he
is
can
the
testify to that.
PowerPoint slide by slide.
Okay, number 14.
Did we already?
13 out. 14.
So, Judge, we don't have to, with number 14, we would need to introduce, I think, the photographs versus putting it up.
Okay,
We would, yeah, as opposed to using it as a demonstrative.
Okay,
There's some
and I mean, if they're
photographs.
already in, then obviously if he needs to testify to them, he can, and if they're not in, you need to be able to, obviously you need to be able to lay the foundation.
Right,
but-
and we may just get, some of the ones that are, as the court has already pointed out, some of the ones that are already in and put them on, just to use those as our exhibits with
Okay.
him.
I completely agree, Dave.
I mean, presumably this shows everybody's, the relation, in a relation to these three people.
It does. He testified about that. But this is just like putting faces to the names and sort of family diagramming, and I think we actually did that earlier. So it would be referring back to something that's already.
I'd be objecting.
Then
Your Honor,
no.
the mother, if I interrupt, I apologize. If the mother of Mr. Thomas testified to family relations, the father of Mr. Thomas testified to family relations, and Detective Dennis testified. Now, he may not have, actually. He may not have. So definitely the parents, the mother and the father, I would be, it's just repetitive.
Okay, sounds like she doesn't intend to use this anyway, upon further reflection. All right, slide 16.
Yeah, it's starting to get late, so I'm pushing up to 1.5
We
speed
still
here.
have a current intent to use this slide.
We cannot use 16.
Okay. Okay, 17.
17.
Yes, I assume that the demonstrative that whoever is testifying is going to use is going to be more consist of pictures and stills that are already in evidence. That I assume is what's going to happen. But what is it now? 3 that they have to change, and the rest are out.
We can as well not use. So I think that what we'll do is just take some of the pictures, photographs that we've already admitted,
Okay,
and use those as exhibits rather than trying
Okay.
to introduce whole hog. This-
sounds
PowerPoint.
reasonable. So 18, y'all still want to be using that?
No, we cannot.
Okay.
We cannot. use
All
it.
right.
Well, except that I think that the photograph in the bottom right corner
Yeah.
were guns that were recovered, but I'll confirm with Dennis. I won't need so that might be something that we could use as an exhibit and not a slide. So if there's anything in this picture, certainly not the top 3,
Okay.
but if that bottom right picture, if we do anything, we would tender it as an exhibit versus trying to put it in on a demonstrative slide.
Okay, and these are all
It was the stuff that was collected from
from
one of the vehicles.
an alleged rival gang?
Yes, after the shooting at 1006 Hill Street. Actually, not the rival gang. This was the one that was collected from the people who were shooting back at the people who were shooting
Oh,
at them.
okay, all right, well, I mean,
But
I can anticipate some potential objections from the defense at the point in time if you seek to tender that, but we'll just deal with that at trial. But don't be surprised, because I certainly think if I were the defense attorney, I might have an objection to it.
I think they wanted this part in because this
Oh,
is from
well,
the
we'll
other
see.
side. This is
We'll
the
see what
guns
the
from
strategy is.
the other side. This is-
We'll see.
Okay.
Okay. That's what makes trials interesting.
So 18 is out.
18 is out, 19,
19, we have not yet introduced that photograph, but I think that we've,
the one on the bottom, or?
yes,
okay.
the one on the bottom. Part of that photograph is part of what was talked about in the interview with Mr. Copeland that has been shown to the jury so far. So we could definitely take out the words, we'll do whatever the court instructs, but that photograph, we can introduce it as an exhibit if it has not already been admitted, and we cannot publish the PowerPoint slide.
Okay.
And in that vein, Judge, with respect to, since we're going through it like that, rather than introducing, no, I think maybe, I was gonna say, rather than introducing the whole thing as just, here's his demonstrator that he's using, since we're cutting it up and using parts of it, rather than saying, okay, we're gonna use this, we won't use the PowerPoint.
Right.
We'll use exhibits that either have been admitted or
Okay.
that we tender through
Okay,
him.
all right. And so that'll be true for the rest of us?
Yes.
Okay.
So the whole PowerPoint's out.
Well,
Am I hearing that correctly?
we won't use the PowerPoint.
Yes, that she's just saying it's going to be easier not to, because I mean, I would imagine he's probably kind of like press play and he's like, here's what happens in slide 1 and slide 2. And if he's not doing that, then it might be easier to do it another way.
Right.
Okay. All right. So then I guess as for the rest of it, we can keep going through with regard to the pictures themselves, or you can just, if there are some pictures depicted within the slides that the defense thinks are particularly egregious or objectionable that you want to go ahead and alert me to, that's fine. Otherwise, I guess we'll just see what happens at trial.
Your Honor?
Yeah.
Wouldn't the same rule that your court said the state now will give us what they believe they're going to introduce as Exhibit 3, Detective Dennis, and we can raise it with you?
Yeah, that would be helpful. I mean, you're going to want to take a look at this and then decide what you actually want to use. So once you kind of narrow that down, if you'll just let the defense know which ones you actually want to use, then they can raise any kind of objections that we could.
Yeah. What happened right now is that the judge more or less forced them to realize you can't use that slideshow. You can't. So they have to use evidence they may or may not be used, have been used, or evidence they plan to introduce through that witness, which means they have to present it to the defense so they can, in good time, so they can make the proper objections, which the prosecution should have done all along. But here we are, 10 months in, and the prosecution is still trying to wiggle out of their responsibilities. Let's continue.
Get taken care of outside of the presence of the jury beforehand. That's fine.
So
Thank you.
Can I just make an observation?
Sure.
Or an objection? So before this honorable court took over, there were lots of objections as to, it was Detective Dennis allowing to say his investigation. So not a witness came in, the crime lab person didn't come in, just he was allowed to say, I learned of, and these CAD reports, I objected to everything on confrontation clause and hearsay, and the former judge denied it. So it all came in. I think the state, is about to do the same thing with the same witness, and I will be objecting again. And I also have this section. I'm looking for Georgia cases.
Okay.
It says, this is, I have a couple cases. This is United States versus Wynn, Nguyen, F, that's wrong, 504 F 3rd, 561, 5th Circuit, 2007. Thus, while summary witnesses, which is what I call Detective Dennis, may be appropriate in complex cases in certain circumstances, they are improper for introducing evidence that the jury has not previously heard. We repeat our admonition that the government may not use summary witnesses for inappropriate means. While such witnesses may be appropriate for summarizing voluminous records, as contemplated by Rule 1006, rebuttal testimony by an advocate summarizing and organizing the case for the jury constitutes a very different phenomenon, not justified by the federal rules of evidence or our precedent. So to me, this is what I call a summation or a closing argument. And I know that the court struck it, so I don't have the same exact situation as my motion to exclude this, but this whole thing is a closing argument. This is PowerPoint with a closing argument. I understand it's no longer like that. It's dismantled, and now we're going exhibit by exhibit and rulings. But my point to the court is, if you can just, I'm not asking for an advisory opinion, but this is going to be, there's 2 Detective Belknap, 1 Detective Gaither, maybe 2, but 1 Detective Gaither, I remember, 1 Detective Dennis. They've all been over objection, qualified as experts. They're on the exact same situation. And now we're going to replow. Detective Dennis already testified as to the alleged back and forth. He already said all this. So did Detective Gaither. It's all over objection, but I would object that it comes in now again.
All right. And what would be, what's he going to be talking about new? Why are y'all presenting him again?
So because he's sitting through some of these, specifically some of the interviews that we were
Okay.
talking about, some of the actual shootings that we're showing the evidence of, like on April the 28th, the Hill Street shooting. He touched on them. We did not get into, like, he as an expert talked about what their investigation led them to do and sort of what their investigation entailed. He didn't talk about the details. We won't be getting into rehashing something he's already talked about. The stuff that he's going to deal with now is going to deal with specifically the interviews that he conducted, depending on what the witnesses say. If there are some instances where, we don't need to play the interview because they say exactly what they said, then we won't do that. But we're at a different part. He is a fact witness, and he's still he has still been qualified as an expert by the court. So we won't be rehashing stuff that he's done, and we won't be using, I'm not certain what Mr. Steele says.
I hope that the defense will bring up, when they have the time, that Miss Gaither, Investigator Gaither, the most incompetent cop I have ever heard of, they had a Daubert hearing in front of the jury. A Daubert hearing is specifically construed and designed to be held pre-trial, so they don't have to bother the jury with it. It also allows me to, or allows the defense to ask questions to the supposed experts that might bring hypotheticals in about their clients and stuff. You should not ever have a Daubert hearing in front of the jury, because it doesn't allow the defense to go into depth about what may not, and stuff like that. I saw somebody complaining about ads. Here is my, hold on. I will actually show you how I do this. This is the monetization. Oh, sorry. Let's show it instead. And I have to go. I will put that out for now and do it like this. As you may see, it's on, and that is just for me to see if the YouTubes accept what is going on, and insert mid-roll ads manually, which I don't. So you should not have mid-roll ads at all. That doesn't mean that you don't get them, but that is YouTube putting them in. Oh, not my ads. Okay, no worries, because I kind of like showing this, because it shows, let's see, like this. This is what I do. The recap crew, they will get one ad every 30 to 40 minutes. But that's only for the recap. You who are here live, you will get probably an ad going in and one ad going out. That's it. Because I don't like ads. Would I... How do I say this? Would I earn more by having another thing going on? Yes. Probably. But I think the experience for you guys is better live without ads. And I'm here for you guys. All right, let's get back to this one. Let me put myself down here and let's get those up. Okay, let's continue.
You know, he objects to summaries. As experts, they're allowed to talk about how they arrive at certain conclusions.
Yeah, I think there were maybe like a couple of different objections in there, but it sounds like one of the objections or potential objections would be if he's going to get up and basically rehash the same thing he already testified to about how, you know, the theory is that all of this came about because it was the culmination of, you know, some gang wars, basically.
We've already
That's already been covered, so he should not be testifying to that again.
Right, we don't need to, but specific, like the April 28th shooting, like we haven't put up all the evidence in.
Okay, nobody in here is being charged with that shooting, right? That's part of the story of some of the crimes that are charged in the indictment, right?
I think the court is saying that they are over X. Some of them are over X. They're listed in the indictment. If that's what the court is saying, the answer is yes.
Okay, so I may be thinking of the Hill Street shooting as something other than what it really
The
is.
Hill Street is not. The Hill Street is not.
Right, that's when Woody and his girlfriend get shot at, right? Or no? Okay, all right, sorry, there are a lot of shootings that I haven't been in this case the whole time, so. All right, so, but I guess, so let's take, for example, that one. I mean, we're not gonna need to get into the nitty gritty of that one, because that one, all that we need, all for the jury to know for that is it happened, some people believed it was a rival gang, it, you know, made the beef worse. We don't need all the details about how many bullets were found, right?
That was free to read. That was Lucci's mom. And so
Well, that was another one, but.
So the overt acts connect that shooting with the ballistics from that shooting.
Okay, so for that reason, that might be relevant. but-
And Lucci's a central sort of
Right.
opposition figure in
Okay,
the whole.
well, I guess I'll just have to take them as they come, but we do not need a whole entire like crime lab, but here is, you know, what you would put in if you were the state prosecuting that shooting, when that is not an overt act and it is just something that happened along the way that's part of the story. I don't want us to be having a mini trial about that.
And we've scaled back everything
Okay.
in the indictment, even like we were saying yesterday with the Rodelius Ryan murder.
Okay.
We scaled everything
Good.
down
Okay.
like that, so
All right.
as not to.
So are there other objections encompassed within what you just said, Mr. Steele, that I need to be addressing?
I don't see why Detective Dennis, through his investigation, is allowed to say, oh, there was a Hill Street shooting and this was gang related, or this was done by this gang in retaliation of this. And we linked up later through the GBI crime lab, a weapon that was used in this shooting and another shooting. You know, to me, that's all confrontation clause. And the investigation doesn't matter. They could have done the greatest investigation. What matters is that the state put up competent evidence before this jury to determine the charges and the elements in the indictment. So to me, it doesn't matter what their investigation was. Now, I have challenged the investigation that they did not verify or corroborate. I have no problem with that, saying, well, I did verify and bringing in the witness, or who the witness was that they spoke with. Maybe not what they said, but what happened last time with the predecessor judge was over objection. Detective Dennis and Detective Gaither was able to say, oh, we verified that this happened in relation to this, and this happened because of this, and this started a chain with this. And this whole thing started in the fall, by September 2014. There was no witnesses here.
Okay, well, I mean, that's the subject for cross-examination then.
It's hard to cross when I have no reports. I have no reports. I have no expert report. I don't know who to interview to say, no, that's not.
Exactly. How do you cross-examine when there are no reports, no notes, and no witnesses?
True. I never told them that. In fact, I told them something different. This is all to me like I have a bag over my head and I'm getting smashed with a baseball bat and I have no idea where to hit because I don't have anything. And I've asked for reports. Judge Glanville told the state to produce it to writing. This is all confrontation clause and it's all coming in as a conduit through some quote expert. And it comes through many experts. And to me, it's just like not having a trial.
Okay, well, I'm sure you'll be able
No,
to
Gigi.
undertake an effective cross-examination of this and every other expert witness. I have been told since I've been in the case in front of y'all in court that there aren't expert reports. Does that continue? And y'all were going to circle back and ask whomever over at APD to do an exhaustive search, even if people were retired. What happened from that? Has that been
For
conducted?
police reports, yes, we were, actually, I think the court told us to do it for a specific act, and I can't recall which one it was, and we did, and there wasn't, but we have done that. We have provided the police reports for these acts that are shown, that we're showing evidence for, and that we are asserting in the indictment.
All right.
So
That is a lie. Because Ms. Love has asserted over and over and over again that the reports are missing, especially the ones from the so-called experts. Now, in my opinion, my personal opinion, if there are no reports, no written down, the confrontation clause should apply, no matter what the prosecution says. And if there are no reports and you can't confront the information in these non-existent reports, then the testimony should be out in its entirety. No, Alda, there are absolutely zero, none, nada expert reports. And the judge tells the prosecution, you need to ask them again. What I need is a court order to get the custodians to write under oath, under the penalty of perjury, that these reports do not exist. That hasn't happened yet. So far, the only thing that has happened is the judge telling the prosecution, go find it. And we know this prosecution has no issues whatsoever to lie to the court. I want to see the custodians of those records either on the stand, under oath, or an affidavit under the penalty of perjury. Until then, I don't believe Ms. Love or the prosecution's team at all.
Okay, you recall that I did tell y'all to go back once again and say, we don't care if people are retired. We really need you to find this and make sure there's no reports in it, right? Y'all
Yes.
did that?
Yes.
And
you
that produced
did.
nothing?
No, we have
Okay.
nothing that we haven't turned over because
Alright.
what we did, what the court required us to do was, it was for a specific one.
I don't think it was.
Hold-
I mean, it may have been for a specific one and then everything else. But anyway, if it wasn't done for everything else, do it for everything else right now.
Your Honor, could we take a very brief restroom recess?
We just had one less than an hour ago. So no,
I'm
sorry.
Okay, I apologize. Mr. Atkins is reminding me that you're talking about gang expert reports and things like that.
Yeah.
And yes,
Yes.
we don't have anything extra. We will go back again because I've gone over and asked homicide. I've asked
Yeah.
gang, I've physically gone over to the gang unit, physically pulled out boxes of stuff. I will continue to inquire.
All right, well, I don't know that, the best use of your time is to
She's
pull up
lying.
boxes and look
I
through them
think
without
Ms.
the
Love
police
is
are doing it.
lying
You
to
need
the court
direct them
again.
to do that.
Yeah.
And so with regard to the gang experts, did y'all go back and say to somebody over at APD in gangs, hey, we need anything there is, even if these detectives are now retired?
Well, we had done that before the court ordered us to.
I know, but then I ordered you to, so did you do it again?
Okay,
Because I
so
ordered you to.
we have not inquired a second time and I apologize to the court. We're
That
gonna do
is-
it again. I will do
I
it.
pretty
personally.
clearly told you to do it again.
That's what he's reminding me.
Yeah, well,
So-
Mr. Atkins, you could have done it.
Yes, Your Honor. I'll go make a phone call now.
Okay.
And can I mention something?
okay.
It came out during trial, during a motions hearing, that there is what I'm going to call a black book. And it's all the gang information. at
Yeah.
Okay, you seem like you know about it.
I've
Well,
heard about this before.
okay, well, I
Yeah.
don't know about it. And we were told, we were given the Heisman. We were told that we're not getting that. Detective Dennis said he no longer works at APD, so he has no access. Detective Gaither said the same. Detective Belknap, who continues work there, says that's not for public information.
Well, I would imagine it is not. However, if such a thing exists, do y'all know what Mr. Steele's referencing?
If he's talking about what Detective Dennis said that he used in the beginning of his career as a law enforcement officer where he collected information, I think maybe he called that maybe a black book. I don't know if he's talking about that or if he's talking about the information that they keep on gang members. I'll let him clarify, but
All right. Do you know, Mr. Steele?
I'll take anything that has to do in any way with the testimony in this trial to either be able to go and interview the witnesses, confirm the witnesses. There was a lot of talk over objection. The policy of APD, how they qualify somebody as a gang member,
Oh.
it's self-admission, it's somebody else who's reliable, would say that they're in a gang,
Okay.
they hang out with somebody, all that's in this supposed book. I don't-
okay, that's entirely different.
Okay,
because-
so you now do know what he's talking about.
No, that's entirely different. Detective Dennis talked about and Detective Belknap talked
Mhm.
about how they identify gang members
Okay.
and what criteria they use. It
All right, is
not
that
true
something that is in
something in a
writing?
black book.
Well, whatever. Is it something in writing?
It's I think that the criteria, those criteria that they use, that is something that is a written sort of criteria,
Okay.
and I'll
All
get
right,
that.
let me propose, if that's easy to get and they don't have kind of security concerns with it being provided to the defense, then provided, if they do have security concerns, then it can be satisfied by saying, Mr. Steele and anybody else on the defense team, you can come look at this written policy, at 12 PM on XYZ day over at APD. That satisfies it also. So in some way or another, if there is a written something that is how they classify, then give them access to it in one of those ways, okay?
I will, and we will also check to make sure that we've not already given them standard operating procedures as it relates to gang
Okay.
unit.
Well,
and gang
obviously, if they've got
identification.
it already, then they've got it.
But in terms of being able to cross-examine the witnesses on specific incidents that they've discussed, we've turned over entire files relating to each of these incidents.
Okay. All right. It sounds like what Mr. Steele's talking about is the sort of policy that you just mentioned that are the guidelines, the criteria.
Actually want the specifics of who they spoke with. They're talking about,
All right. Well, they may or may not have anything like that in writing.
Well,
And you can always just interview the detectives
well,
to ask them those things.
I have interviewed the
Okay.
detectives, and they tell me that they're not releasing that information. They would speak with somebody. They'd speak with Brian Steele. Brian Steele would say that Keith Adams is not involved in criminal street gang activity. That would go into some sort of book. And they would speak with Carlton Matthews, and he would say that Brian Steele is in a criminal street. That would go in some sort of book. I'd like to see that because they're speaking about, we corroborated this. So I asked on cross, who did you speak with? I'm not going to tell you. Well, why don't I have the right to know?
I don't know. Maybe they consider them confidential informants.
He never said,
have to get-
I don't think he ever said, I'm not going to tell you, Judge. I think
All
that
right,
what
I'm not going to relitigate it. If it comes up again, we'll deal with it then. Okay. So I'm not even sure how we got on that. Oh, but Mr. Steele, you've said a couple of different times that you object to certain portions of CAD reports as being hearsay, and you were going to give me some law about that. And I don't know if other CAD reports are going to come in or not, but. Okay, well, provide it, and that way they provide it to the state as well, because if it's clear law, then they can just redact those portions of CAD reports, which might need to come out as hearsay. Okay,
So I have a KA K-A-M-U-S-O-K-O versus state.
I'm sorry, start over. I just didn't get that at all. K-A,
K-A-M-U-S-O-K-O
okay.
versus state 362 Georgia Appeal, 276 footnote 3.
And what does it say?
868 Southeast UD 252, 2022. Says, Camusoko makes no distinction between any particular statements and declarations, and therefore has abandoned any challenges he may have regarding particular statements or declarations. There is nothing for this court to review where the appellant has failed to identify precisely what statements he challenged. In addition, although Camusoko mentions in passing that whatever was said to the 911 operators was filtered through people who did not testify at trial, he fails to include either citation to authority or meaningful legal argument that the CAD reports were inadmissible because the 911 operators or other persons writing down the declarant statements did not testify at trial. He therefore has abandoned appellate review of any challenge to the CAD report on this ground as well, and that ground is hearsay and confrontation clause. It's in Division 2 of that opinion, but I read from footnote 3.
All right, so, I mean, that doesn't establish that if objected to, it would have been an objection with merit. It's just saying, hey, you're raising it on appeal, you didn't raise it below, we're not going to deal with it.
It's not right, but the CAD
So,
report
okay,
could be
maybe
count-
you could come up with one that instead of saying this is a potential issue, says, all right, here's the issue, and in addressing it, here's the law on that. Can you try to do that? Thank you. All right. Okay,
in this case, in Division 2A,
all right,
where the footnote 3 is,
okay,
and what the court said was it's admissible under an excited utterance of hearsay. It's
Yeah.
hearsay with an exception.
right,
So
okay,
my point is, some CAD reports they don't identify an emergency situation. So they're identifying a past event. So that would be a confrontation.
okay, well then, you'll just,
It depends
if you
on the
plan
CAD.
to make that objection to every CAD report, then give me the CAD reports
Right.
and I will make a ruling.
That's right.
All right, let's do that. So that can be on the agenda for tomorrow. Okay, thank you for clarifying that. I do realize that there might be times. I just thought y'all had some kind of blanket. This part of the CAD report is always out. And that is not what we have.
Right, it's like
Okay.
911 calls. It just-
Yeah, no, I'm clear now with what you're saying. All right, so we've done the PowerPoint. So I am going to give us another quick break, but I'm going to say, and I'm going to say this once, and I don't want to have to say it again. And this is kind of what you say to little kids when you're on a road trip with them, is if we're taking a bathroom break, even if you don't have to go right then, if you could hold it for another 40 minutes, just take the opportunity to use the restroom so that we don't then 30 minutes into court again, have to take a break because now you can't hold it anymore. Okay? All right. So we'll have a little recess.
Yes, Takisha. They did finish the PowerPoint slide by the prosecution, saying, well, that PowerPoint is out completely. We just have to redo the demonstratives with evidence that are already in evidence or with evidence that will be introduced through that witness. So the entirety of that slide out, which it should have been from the very beginning. And let's skip forward. Break. There we go. There she is.
Ask on our task list. Open suggestions are all pick with. I know we still have to do the excerpts from the wiretap evidence, so that might be a good thing to turn to next.
I meant to bring this up yesterday. We've been labeling the excerpts from the wiretap as potentially co-conspirator statements.
Right.
And I think the state announced that those wouldn't be coming in until Investigator Viverito
Mhm.
testified. What I meant to inquire about the other day was, I know that they've suggested that there are additional co-conspirator statements. I'm just wondering if any of those are linked with witnesses coming up soon.
Hang on just a second. Nobody say anything because our court reporter needs to plug in back up.
Skipping ahead.
Our court reporter is still rebooting, so I thought you might have something that was not something we needed to take down. Okay.
Some research to do on our case tomorrow. So with Mr. Williams' permission and Mr. Adams' permission and the court's permission, I was going to do that at my office. And I will not be here tomorrow, if that's okay with the court. And Mr. Williams said that's okay with him. He can speak for himself, and Mr. Adams said that's okay with him.
All right, sounds good. Thank you. Okay, we're back up now. So I don't know if all of what Mr. Sharp said got on the record. Do you mind just reiterating it?
So, yes, I will. We put off, we suggested that the wiretap co-conspirator statements are going to come in through Investigator Viverito, which would be later on in the trial. But I believe that the state has also stated that there are additional co-conspirator statements or alleged co-conspirator statements that are not part of the wiretap. And I was just suggesting if those involve witnesses that are coming up sooner, that might be something that we need to address.
Okay. Do we have other co-conspirator statements that are not the ones from the wiretaps coming in through to Investigator Viverito?
So, since we won't be getting to the wiretaps until she's number 91, witness 91, in terms of, okay. My question to the court is, would the court allow us to go in order of the witnesses that are coming up and deal with the buckets of?
Yeah, that's fine. And I think that's kind of what the defense might be trying to figure out is, do we have some co-conspirator statements that are going to be coming up soon? And I'm fine if it's easier to just say, okay, we're talking about co-conspirator statements now and tackle the ones that are coming up soon. That's great. Or if we want to go witness by witness through, here's the evidence that's going to come in with this witness. I think either way makes sense, but let's do one or the other. So yes, it sounds like maybe there are some other co-conspirators or alleged co-conspirator statements that are going to come in soon.
Not any that are coming up soon. Not soon.
Not soon.
The witness buckets would be the most. The next, Jamari Holmes is the next time that we'll have co-conspirators.
Can y'all all hear her?
I'm sorry, I'll get closer to the mic.
Okay.
Jamari Holmes's murder is the next time that we'll have that issue. And that's the one that we were discussing at the beginning of court with Your Honor and Mr. Williams and Ms. Abbasi. So the co-conspirator.
That's a little ways away.
Yes.
Does that answer your question?
I'm fine with that answer. As long as nothing sprung on us at the last second with these witnesses coming up, I'm fine with that answer.
Okay, so they do have what those co-conspirator statements are, right? We don't need to litigate it right now.
I'm sorry, I missed what the court.
Do they have whatever the co-conspirator statements are, whether they're from the wiretap or a different source? Do they have them all?
Yes.
And they been identified as potential co-conspirator statements?
Yes, Your
Okay.
Honor, for the most part. Just 1 second, I'm going to confirm one thing.
Okay.
And she's shaking her head because she just lied to the court again. None of that is identified. All right, there's over 200 of you here. Have you all pressed the thumbs up? If you haven't, please do so. And if you haven't subscribed yet, also please do so. If you know you're subscribed, please check again, because sometimes the YouTubes unsubscribes you without your knowledge.
Sprinkles folder have potential co-conspirator statements in them. We don't have them extracted out. We just have the ones in there
Okay.
that we intend to use.
All right. I mean, y'all ought to be aware that if there are jail calls by co-defendants, that those might contain co-conspirator statements. So that would be the only thing that might not be specifically identified as that. Okay.
My expectations are correct in line with the courts. The state is going to specifically identify those alleged co-conspirator statements. Correct. I mean, there's thousands of jail calls from probably, I'm underestimating, thousands, yes. So we would need to know what statements, when they're made, between whom and whom, if the state, because we would like to litigate these beforehand. I know the court would too.
We put in the Mike Sprinkle bucket, the jail calls that we're using.
All right. So jail calls y'all intend to use are all in the Mike Sprinkle folder.
The ones that the ones that we have identified that we intend to use, and those are the ones the court told us to.
Okay. So the universe has been narrowed, hopefully substantially. I haven't looked to see how big the Mike Sprinkle folder is, but
If it's the same one that I think they're talking about, it's about 200 calls,
okay, well, then-
15 minutes each. So that's 50 hours of,
okay. Which I presume is one of the reasons y'all said, let's hold off on dealing with what's in the Mike Sprinkle folders. So as the state, look here, as the state is itself going through the Mike Sprinkle bucket in further detail and identify.
Oh, who did you catch that? Listen to this. I'm going to go down to normal speed.
So as the state, look here, as the state is,
Ooh. Oh, I think Judge Whittaker is at her wit's end with the prosecution. You don't see that from a judge who isn't really, really angry. Because as soon as the judge starts talking, you stop, sit up straight, and you watch her. And they just kept, yeah, that's not a good look.
itself going through the Mike Sprinkle bucket in further detail and identifies for itself the specific co-conspirator statements that it intends to introduce. Please identify those as well to the defense. As soon as you know, let them know.
So we have 14 in the Shannon Stillwell folder. We could start there since that is his client, Mr. Shart's client, that we could actually review.
Okay. Let me get some clarity. So in the Stillwell file of jail calls, are those already identified? Just here are the co-conspirator statements? Or are they just like, here's a 15-minute call, here's a 5-minute call? All right. And do you know what portions of those calls yeah. All right. But whether you've broken them out or not, do you know what those are? Okay. So if you can, that's what I'm saying is once you know, here's call from January 2nd. That is 15 minutes. I'm going to use minute 2.5 to 2.9. That's the part I care about. When you know that, let the defense know that. Okay. So if you know that already, instead of us sorting it out here live, give that one of y'all sit there and type it up and send it over. They can look at it tonight. We can deal with it tomorrow. Okay. And similarly, do that for everything else. All right.
Hi, Casper.
So that it sounds like the most productive thing to move to next, unless somebody else has a different idea, I'm willing to listen, is to just open back up, the witness folders and move on to whomever the next witness other than Mike Sprinkle is going to be and go through that proposed evidence for any kind of evidentiary issues we can hash out now. All right, let's do that.
All right, I'm trying to skip ahead.
The first 30 witnesses.
Yeah,
So everybody
prosecution.
can
What
find
did you
that again.
prepare? What did you prepare? Okay, I'm just going to say this. I'm going to do maybe 20 more minutes. And because it's almost midnight and you guys need to get your sleep and I need to get my sleep because tomorrow is a somewhat big day. For you who don't know, I've traveled across the United States on my in a road trip. And tomorrow Dave will we will first watch the Henry Ford first factory. Then we are going to Motown Records. And after that, I'm going sailing. And that sailing trip will be live on my road trip channel. And if you wonder what that is, just point the name here, N.Starow, and road trip, and you will find it. So yeah, I have a big day tomorrow. I don't know when we will be back, but I will keep going with the recaps as much as I humanly can. But going past midnight, I need sleep, and I assume so do you. Have I ever been sailing before? Yes, but that is maybe 25 years ago. And so that will be fun. But it will be live streamed, so you will either see me enjoying myself or you might watch a stream of me leaning overboard hurling my guts out. I don't know. All right, let's keep going the last 15 minutes or so. And then I will pick up from wherever we leave off.
Your email, you just tag on to one that already existed. Pretty sure? That's right, right?
Yes, Your Honor. It says 30 witnesses, and then it has 8 August 24 in parentheses.
All right, y'all let me know when everybody's there. Everybody there now? Almost? All right. Has everybody got the 1 through 30 Dropbox link up?
We have the full, Kendra has the folder.
Okay,
I don't know if I-
great, thank you. All right, I heard from 2 of 6. Y'all ready? Okay, 3. Stay ready. Okay, Mr. Matthews, you got it? All right, who else? Are you ready, Mr. Sharp? Okay, Mr. Adams or Mr. Steele? Okay. All right, here's the one we're waiting on. Okay, we'll get you, okay. All right, I think that we yesterday had gotten, other than Mr. Sprinkle, through, there was nothing with regard to any of the phone custodians, right? Sure. Cell company custodians.
Your Honor, if they would like to stipulate, we can, as to those records, we can just bring in the records themselves and save that time, but.
That would be nice. How about it? Miss Westmoreland doesn't want to. Okay, no, that's not going to happen. All right, well, so we'll have 3 more witnesses, but with regard to the evidence within those, any kind of motion and limine type issues we need to deal with on those. Thank you. Okay, then James Burney is the next witness listed. Do we need to look at anything with him?
The expert from the FBI phone records.
Okay,
This is one that I voiced an objection to repeating the testimony because Agent Racy talked about for a long time where the phones were located. The prosecution stated that based upon questions by some of the lawyers for the accused, that they needed to do something else. I'm still holding my objection because I believe it's going to be, I looked at the report, it's the same thing, maybe a little nicer because it was done nicer. And I don't mean to insult Detective Racy. He didn't have like a, a chart, but I just believe that it's the same. And by when the same, I'm talking about the April 26, 2015 shooting of the tour bus of Mr. Carter, a performer known as Lil Wayne. Otherwise, no, I don't have any issues with with
Okay.
Agent Burney.
all right.
And Your Honor, per the court's guidance, this April 26, 2015, we are not discussing Special Agent Burney. This, when he speaks on specifically the January 10, 2015 murder of Donovan Thomas, that's the only cell records he's going to be testifying to right now. He does analyzes cell site tower data for other acts in this case and counts. So he's one of those witnesses that testifies multiple times when that act comes up. So what Mr. Steele, specifically the April 26, 2015, we will not be
Calling him for that purpose?
correct, Your Honor.
Okay, but so when he's called here, it'll just be for the January 10th,
2015. yes, Your Honor.
2015? Okay, anybody else? Nope, I hear, all right, not hearing, but I'm seeing nods, no. Okay, all right, great, we'll move on to the next witness folder. All right, GBI Firearms Voss in Wheatzel or Whitesell.
Oh, is this a
Any
toolmark
issues
guy?
on those?
Trying to skip ahead.
Well, a few weeks, 2 weeks ago, maybe, Mr. Weitzel is going to be called. I believe there's on the email that we sent to the court and to counsel for the defense, the peer reviewer and the verifier for David Voss would be called rather than Mr. Voss.
All right, and is that peer reviewer / verifier Weitzel?
No, it's actually Vanna Kelly.
Vanna Kelly? Okay.
Yes.
Is that Ms. Kelly?
Yes.
Okay. Does she have her own reports?
Actually, what we're doing is getting the data, the underlying data. So she verified these. And so any underlying data that she has that they may want, just in case they want it, we have to get that for them.
Okay.
It's unclear to me the work that I guess Ms. Kelly did on this case. It's unclear to me what the work she did was, but obviously, Your Honor, there's potential for confrontation clause issues involving Ms. Kelly testifying to the results.
All right. I would presume, I mean, typically when they testify, they say, I ran all the tests myself.
Right.
And obviously if they didn't, then that's going to be problematic.
Right, it would be. She looked at the evidence under the microscope herself and came
Okay.
to the same
All right. So
conclusion.
she will be testifying to her own conclusions, not to his
Not-
conclusions.
right, hers match here.
Yeah, this is this, folks, is not peer review in a scientific sense. Peer review is when a completely separate person or entity goes through this completely blank. And if that person comes to the same conclusion, then you may come near peer review. What they are going to do now with this witness is having a colleague of the previous toolmark expert testify that, yes, I checked that other person's result, that colleague's result, and that is all they checked, which is not now, has not, and will never be proper peer review. It is appalling. It should be thrown out of court. Toolmark evidence, toolmark experts are, in my opinion, at the level of a crystal ball or tarot cards. It is not what they present in court. And it should be thrown out. The entirety of toolmark expert testimony should be thrown out because it is not reliable at all.
And he was the one that put out the report. She verified his by going through and looking at that physical evidence under the microscope.
Okay, but her conclusions will be based upon her own
Correct.
testing and observations.
And to my understanding, we don't have a report from Ms. Kelly. If she, maybe she's not writing a report, I don't know, but I'm bringing it to the court's attention, the state's attention, that my understanding is we don't have a report from Ms. Kelly. So if one was generated, we need that report.
That's what I was just saying. She did not generate a report, but her underlying notes and data, that is what we said we would get for them because her conclusions.
Okay. She doesn't have a separate report, but she's got notes and data, and y'all will be provided that when? Did y'all have that yet from her?
No, I spoke with the GBI last week and I'll follow up this week.
Okay. Let them know that this is an ongoing trial and they need to
I will.
provide it ASAP and then provide that over.
That should have been provided before the trial even started. They are 10 months late with that crap.
ASAP to the defense. Okay,
Also, with respect to Agent Bernie, if we could swing back to that.
sure.
He will likely not be testifying until the end of September, in which case any time needed, we believe, for the defense to review his analysis of the April 26th incident would have, we believe, that rather than having him testify 2 different dates for those, for the incident here and the incident in April, would be obviated by the fact that he's going to not be testifying until the end of September, as opposed to having him testify at the end of September and come back 2 weeks into October. So I guess we're asking for clarification on whether or not he can just be brought in, whether that is not enough time for them to look at the additional reports that they were given last week, or was it last week, week before, week before last, right?
Okay, let's find out.
The issue isn't the amount of time that we had to review Agent Bernie's report about the April 28th incident. The issue is that Detective Racy already testified concerning the movement of the cell phones. And and the state seems to be justifying this on some sort of cross-examination. That really the the allegation is that Mr. Winfrey was moving with the bus, and the allegation, which I strenuously deny, is that Mr. Stillwell was moving with the bus. Mr. Stillwell didn't have a cell phone, so I'm not sure what the point of any of this is in the first place, much less hearing it for a second time.
Okay.
Yes, Your Honor, during cross-examination, they challenged Detective Racy that he was not an expert and therefore that he could not testify as to what side of the tower that the phone was on, only the tower placement.
Okay.
And because it was specific as to what side of the tower it was on, that's why we asked Agent Burney to do the analysis based on their cross-examination. I think specifically Mr. Weinstein objected that because Racy was not an expert, he could not testify to what side of the tower that the phone was actually on, which is important given the movements of where the phones were at particular times, the evening or the morning of April 26th. So that's why it became relevant for us to get Agent Burney to do the analysis, because he can talk specifically about what side of the towers the phone was on at a particular time.
All right. Which phone?
This was, so it was Mr. Winfrey's phone, also the phone that we're identifying as Dolly White or Max's phone. There may be about 3 or 4 other phones that I can't just recall off of the top of my head, but all these individuals were with, ascended upon the compound, which is where they started, and followed the bus all the way up to the hotel,
Okay.
and then went down to the studio afterwards.
Okay. And does anybody identify a phone as one belonging to any of these co-defendants?
No.
Nope.
I can't get this to go back.
The point fake expert. Yes, Felicia, I agree.
Hang on. All right, go ahead.
Only phone that he analyzed from these defendants here would be Mr. Williams' phone, because Mr. Williams' phone, we had that plotted that he was in Baton Rouge at the time of this, which was consistent with.
No phones.
Okay, so tell me why we need to hear from but tell me why we need to hear from Mr. Burney about the side of the tower that other people not on trial hear.
Because it's a part of the conspiracy and it corroborates what other people said about the movement and where everyone was at the time. And because they challenged it so much that we can only say that this is where the tower was, but with no more information.
Okay, and was there testimony, whether there were cell phones for these people or not, was there testimony that X, Y, or Z co-defendant on trial now was with this crowd?
We believe that some testimony will come in soon that Shannon Stillwell, although we did not have his cell phone,
Right.
that Shannon Stillwell was present at the time of the, it has not come in yet.
Okay, all right. So then with regard to that incident, Mr. Burney's testimony should be on the narrow issue of, I analyzed these cell phones and I can say that it was this side of the cell tower, but we won't need, I would think, to go through, I don't know, but did Detective Gracie give sort of the overview of here's how we know all of this anyway, and here's what,
Correct.
Okay,
Yes.
so we won't have to go through all of that again. You can just cut to the chase of, yeah, I know all of that stuff too, and here's what else I know.
Yes.
Okay.
Yes.
That works?
Hmm.
All right,
That's a
so
good
moving
ruling.
back to,
Is it- Can I ask you a question?
Yeah.
Does that exclude then Mr. Williams, who's in another state at the time? We're not going to hear about that again.
I mean,
Am I correct?
are y'all gonna bring that up again?
Because that
Yes,
was
but-
testified
but-
to.
In the sense that he received that document and he plotted that as well. Yes, but we don't have to go into the details of it, but I think it's part and parcel of what was happening that night
All right, hang
that
on.
they challenged.
Hang on. Did anybody from the defense challenge the legitimacy of Detective Gracie's conclusion that Mr. Williams' cell phone was in a whole other state?
I agreed with it.
Okay, then if there was no challenge to that, that shouldn't need to come up again. Right?
Can we ask him whether he plotted that phone? Because if he's going to talk about some of the records, we think it's important that at least the jurors know he didn't.
Yeah, I mean, if it's like that could be like a one question.
Yes.
Yes, and it was in somewhere else entirely, which I would think Mr. Steele at least you would like. Okay. Well, that part certainly wouldn't. So you, okay. All right. That is what I said. Okay, so back to the 2 firearms examiners who are going to be Kelly and Weitzel, where we can move on from that. Silence is yes here. Okay, so next is Officer Zaffa.
Okay, this is a natural stopping point at 3:38, which leaves us with just over 2 hours left. No, 1 hour left. Yes, Erin, I'm well, I'm live now, but I won't be in 2 minutes. So, okay, this is a natural stopping point, and because I need some sleep, and I would assume so does you. So do you. Yes, as per usual, folks. Thank you for allowing me to do this. I'm traveling across the United States. I have a few days here in Michigan before I travel back to Sweden. And I will do as much as I can, but some might be left until I return to Sweden. I will do as much as humanly possible. But today I need to cut off a bit. Again, thank you guys for allowing me to do this. Thank you for allowing me to try to interpret this faster clock of a trial with the knowledge and the experience I have. And as per usual, hug your family. Unless your family's crap, then screw them and give your love to the people who deserve it. I will see you all here back tomorrow for a continuation of the recaps, okay? I'll be sending you off to MG Law, who is doing something about Otter Creek. Well, you know MG Law, he's a good man. And it will be interesting, I promise you. And I'll be sending you off with the song Viking Road Warrior. See you tomorrow. Bye-bye.
Viking from Sweden drives across